anticipate that the state is going to attempt to introduce 3 photographs from my client's phone and iCloud account,
Okay.
and I'm going to be objecting to that.
Will be 35, if this card is still accurate.
Yes, 35.
Correct. This is a part of the cell phone records, but a different cell phone record.
So what's the objection to the photo?
Judge, the objection to the photo, Your Honor sees them, is obviously there were no guns recovered from my client or from the search of his residence. The one photograph, and I don't know what letter it is.
Not lettered until we're calling things if we do letters.
Can I see,
can.
can I get the,
I'll
can I
label
see the
them.
photo?
These are the photos, yes.
All right. All right, so you're starting with a gun photo. The MAC 10.
Are you, Ms. Bradley's arguing something?
I just wanted to see which photos.
Oh,
And then close. All right, so what's the objection to it?
My objection to that, Your Honor, is that that hasn't been correlated at all ballistically to the case. It has not been found in this case to be examined. I don't know if there's going to be any potential evidence as to what type of firearm that is or what type of ammunition could be used in that.
It's a 9mm.
firearm. Well, it's not for, I understand the court has independent knowledge of firearms, but I'm talking about based on testimony in this case.
Okay. Do you have anybody qualified to talk about this firearm? You just can show a picture of what is probably a semi-automatic clone of a MAC-10.
we are going to allow the jury to make a determination as to whether it's consistent with the firearm that the defendant, Mr. Hammond, was in possession with in the East Tampa pond video. I have screenshots of those videos that we would be using
Let
to.
me see the screenshots of the one in his possession.
This is the East Tampa pond video at 21:04:11 from a distance. We're talking about the defendant that was located crouching at the fence. Your Honor, these are the zoomed versions of those videos.
There's somebody crouching at the fence?
Yes, may I see your, I'm sorry. Yes, the individual that's here, I can play the
Right.
video for Your Honor as well,
Like
but the
I've
state will
seen, yeah.
assert that what's in his hand is the same or similar to this weapon, and this weapon was photographed on the device the day before our homicide.
Okay.
The additional 2 pictures, well, should I allow the court to rule?
Well, I'm still, I mean, I can't even see that, anything in his hand. I can see something in his hand. Now, when he's walking on the video, you can see that there's a handgun in somebody's hand.
Yes, Your Honor, and I can play the video as well. When we slow down the video, it's a little bit easier for at least the state's position to see the specifics of the weapon that was back there, but this individual has, what's the state's gonna argue, the same firearm in his hand at the time.
Can you see the extended magazine in the video?
Yes, Your Honor, so can I please grab the video?
Yeah, let me see the video.
And Judge, I'm gonna play you the video from that same time frame. I'm not sure if Mrs. Bradley wants, if you're familiar or you wish to as well view it, but we are playing this portion of the fence, Your Honor.
Okay.
The video is obviously, in the state's position, better quality than the screenshots, but we just tried to provide the
Right,
screenshots.
run that
for-
again, because I think you can see. It looks like the same type of firearm. You can see the magazine and the extended beaver tail.
The back of the gun
Right.
is the state, yes, yes, Your Honor, it's very unique.
Yep. I would agree with the state that that photograph or that video brings this picture into play. So I'm going to allow it as an argument because it appears to be the same style of firearm.
And then the additional 2 photographs that were provided to the court are from the same device. Those are not dated the day before, those are dated July 9th of 2021, but the state has already introduced stills from the interior of the gas station in which this defendant is dressed in the same attire. And I'll provide the still to the court, or at least a stop of the video from the interior of the gas station, video 1 at 8:39:31.
You talking about the gun holster?
I'm talking about the clothing he's wearing, the same pants and same shirt.
Judge, they already have the evidence of the pants that were located during the search warrant of Mr. Hammond's residence. This photograph that was taken on July 9th of 2021, I believe, is irrelevant to any issues in this case.
This picture shows he has a gun in his waistband. On an inside the waistband holster on this.
The same firearm that's in these photographs, Your Honor.
I couldn't tell you if it was the same because the shirt covers the.
The state's only purpose for any additional photos of the clothing from the device would be to show the outfit.
And there's an
If he-
extended magazine in this photograph as well,
Right,
which
and then
pairs.
that would be a 403 argument, because that is on July 9th, which is not on the date of the offense or the day before the offense, and it's highly prejudicial. There's no way to determine that that's the same firearm. And just possessing that firearm at a different date in July is irrelevant. They have other evidence. They have the evidence of him IDing himself from his interview with Detective Celaya. They have the pants and the hat that were located during the search of his residence. He's wearing sneakers in that, and in the video, he's wearing slides.
It's only for clothing purposes, Your Honor, so if I can hopefully condense the,
If it's only for clothing purposes, then we can cut that picture off at the waist, and I would have no objection to it.
Why wouldn't it be relevant that he has an extended magazine on his possession and an extended magazine in this thing?
Because it's a completely different date, which makes it irrelevant to
No,
whether
it doesn't
he
make it
possesses-
irrelevant. It goes to, I think the better argument would be, is it contemporaneous enough to be, I mean, you're talking about a 403, weight versus the admissibility. Is it admissible, or does it go to the weight?
It's both. It's irrelevant because it's on a different date, July 9th. This incident happened on August 22nd, and it also goes to the weight, being that the prejudicial effect outweighs any probative value. If the only reason why they're trying to introduce that is for the clothing, they already have evidence related to the clothing and what he was wearing on the day of the offense.
State, what's your argument regarding the firearm in the waist, in
in
the
the
extended
waistband
magazine?
of the pants, Your Honor. I cannot with specificity tell the court that that is the same firearm, so I will agree to place a block over the one photo that you cannot see the extended magazine for purposes of showing the entire outfit. We do not have confirmation of the top, obviously, just the pants. The top was not recovered during the search warrant, and that should eliminate any 403 argument.
Okay, so you're gonna block that out?
Yes, Your Honor.
In both photos, I believe you can see something in a waistband.
What I'm saying is I will seek to admit only the photograph with the smaller portion that doesn't show the extended magazine.
I'll just look at whatever it is,
Sorry.
and we can make any further argument.
To use this photograph in lieu of this photograph.
Let's see.
Correct. And to place a marker over this.
Let's see how we're gonna do that.
The
See what
sticker on it
looks
says
like
there's no
after you
gun
do
here.
it, Unless it's obvious,
Okay.
if that's what you're doing. I don't mind if you want to cut it here and introduce it. I don't have any objection to that. If the shirt is the issue.
Maybe visit that on a break, or do you want me to work on that
Yeah,
now?
that's
Okay,
fine.
Okay.
So we
we'll
can
we'll
reintroduce
revisit
it.
that. But I mean, clearly those pants are the same.
Right, I'm not agreeing that I'm gonna just cut it off. We're going to have to figure out an alternative or to revisit the issue at the time. I will do my best to.
That's fine. The pants were located in his residence.
Right.
They have the actual pants. They
They're allowed
already
to
have
show
photos of
the
them.
evidence more than once. I mean, the defense is going to attack the credibility of all the evidence, so why shouldn't the state be allowed to put on all the evidence they have regarding the piece
I
of evidence?
understand, but ID
I mean,
and
at
this
some
is
point
not
it
an
becomes-
issue.
Well, is he stipulated to ID?
He didn't, but I'm not making any
Well, then
arguments
ID
that
is an
that's
issue.
not him, but I'm not making any arguments that that's not
I don't
him
know
in
what
the
argument
video.
you're making, and I don't want to know.
I'm telling you, as an officer of the
Okay.
court, I'm not making that argument.
Well, I trust you. I'm not worried about that.
Ms. Bradley, any comment regarding any of the other cell phone evidence from this device, the search?
No.
Okay. Any other issues we need to discuss pre-jury? Anyone else? We all ready?
Yes, sir.
State?
Yes.
Bailiff?
Do you need this material for anything with this witness? May I?
Yes.
All rise for the jurors.
No.
Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. I take it there were no issues with the court's instructions overnight? All right, very good. State, you may call your next witness.
The state will recall Officer Edward Barreto.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Whenever you're ready, counsel.
Thank you, Your Honor. Good morning, Officer Barreto. If you can please just reintroduce yourself to the jury and spell your last name again for the court. please.
Absolutely. I'm Officer Edward Barreto, last name spelled B-A-R-R-E-T-O.
And Officer, we discussed earlier in your testimony that you went out to the scene and located an individual by the name of Willie Brown. Do you recall that?
Yes, I do.
All right. Officer, when you were at a scene of this nature, or any scene that you respond to, do you have what's called body-worn camera?
Yes, we are assigned a body-worn camera.
And can you explain to the jury what that means and how it works?
Basically, it captures all interactions with law enforcement and the public whenever we're dealing with a law enforcement-sensitive issue.
Okay. And does it turn on whenever you come into a situation where you're dealing in those kind of situations?
It'll sometimes automatically turn on with the activation of lights or siren, but we also manually turn it on whenever we come on scene.
Okay. Did you, in fact, in this particular case, when you arrived on scene, turn it on in this case?
I did.
Okay. And that body-worn camera showed your interaction with Willie Brown?
Yes, sir.
All right. Now, when you saw Willie, well, let me show you what's been marked as States Exhibits 57A through E, and I'm going to ask you to take a look at those pictures and see if you recognize them.
I do recognize them.
Okay. And are those in fact still shots taken from your body-worn camera that you were wearing on that particular night?
Yes, sir.
And do these fairly and accurately depict these particular still shots from that body-worn camera on that day?
Yes.
Judge, at this time, move to have States Exhibits 57A through E admitted into evidence.
Any objection?
No objection.
All right, 57A through E will be admitted.
All right. Now, officer, I'm going to show you 57A right here, and I'm going to kind of zoom in down to this particular location. Detective, was Mr. Brown wearing anything on his wrist?
It appears he's been wearing a watch.
Okay. And were you able to see it on that day? I'm now showing you 57B. Oops.
Yes.
Okay. And 57C.
Yes.
And that's what he was wearing when you encountered him.
Correct.
And these photos are actually from the screenshot taken right after you came upon him at the scene?
Yes, sir.
Okay. And 57D. Again, just showing what's on his wrist at that particular moment, right?
Yes.
And finally, I guess 57E gives a little more, you can see the face of, that's it right there on his wrist, right?
Yes, sir.
And you observed that night?
Yes.
Okay. I do not have any further questions of Officer Barreto, Judge.
Any cross?
No, on behalf of Mr. Sampson.
No, sir.
No, sir, on behalf of Thompson.
All right, may this witness be excused?
Yes, Your Honor.
Thank you, officer, free to go.
Thank you, Your Honor.
By statement, call your next witness.
The statement called James Kwong.
Good morning, if you could raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Good morning, sir. Can you hear me okay?
Yes, good morning.
Good morning. Can you please state your name and spell it for the jury?
My name is James Kwong. James spells James. Kwong spells Kwong.
Were you previously employed with the Florida Department of Law Enforcement?
Yes, I was.
And in what capacity?
I was a senior crime laboratory analyst assigned to the firearms section.
How long were you working with FDLE?
Approximately 19 years.
And when did you stop working with FDLE?
December 2024.
So recently.
Yes.
Were you working or still employed there in the firearms section in August of 2021?
Yes, I was.
And between then and the date of your retirement, had you worked up cases related to firearms
Yes.
and ballistics analysis?
Yes.
Can you tell the jury what your educational background is?
I have a Bachelor of Science degree in Mechanical Engineering and Technology from Temple University. Temple spells Temple. Temple University in the city of Philadelphia. I received my Bachelor of Science degree in 1985.
When you worked with the Florida Department of Law Enforcement with firearms, did you work in any other capacity? So DNA or in any other areas other than with firearms or ballistics?
No.
And what training or experience do you have in the area specifically related to firearms?
Before I was working for FDLE, I was previously employed with the police department in the city of Philadelphia. I started as a police officer on street patrol duties. After 5 years of patrolling the street, I was transferred to the Forensics Science Center, and I was assigned to the Firearms Identification Unit, FIU, where I received 3 years of on-the-job training under a very famous firearms examiner, Police Officer John Farner. Farner spells Finor. I received 3 years of training in regard to the forensic disciplines of firearms identification. Once I completed my training, I worked as a firearms examiner in the city of Philadelphia for approximately 6 years. Then I took an early retirement, came down to Florida, and worked for FDLE. I have a total of 25 years of experience in the area of forensic firearms identification.
Can you talk to us a bit about the Florida Department of Law Enforcement specifically? Is that laboratory an accredited lab?
Yes.
And what does that mean?
All the forensic laboratories under the FDLEs are accredited. The accredited agency is called ANAB, spells ANAB, which stand for American National Standards Institute and National Accreditation Board. It is an organization that sets standards and guidelines for the industries. It also provides accreditation and training to the laboratories in this country as well as internationally.
And when you worked specifically with the Florida Department of Law Enforcement, if I just isolate my question to those 2 decades or so, did you devote all of your time to firearms work? What did your work week look like? What were you doing and how much of that time was devoted just to firearms?
Before I answer that, let me finish my previous answer.
Objection, non-responsive.
Overruled, I'll allow him to explain.
Regarding the accreditation for the Florida Department of Law Enforcement?
Yes.
Okay.
Well, if a laboratory is accredited, that means quality assurance. It, that the examiners and analysts are competent and credible, and their methodologies they use in examinations.
Objection, Your Honor. Mr. Pong is expressing opinion testimony.
Overruled.
That the methodology used in examinations meets and conform to the high standards within the industries. That means the products are reliable and credible. As to the questions about how much time I spend on doing firearms work, approximately 95%. The other 5% go to court to testify on cases, as well as provide training to new trainees in the section.
So if I understood you properly, the accreditation ensures, or there is an insurance in place to make sure that FDLE is sticking by the standards in the scientific community?
Yes.
Okay. Now, you work only with firearms. Have you testified? I think you indicated a percentage of your work was for testimony, but that would mean you've testified previously as an expert?
Yes.
Do you know approximately how many times you have testified as an expert?
In my 25 years of career in this field, I have testified as an expert in the firearms identification approximately 233 times.
At this time, Your Honor, the state would tender the witness.
Any questions from any of the attorneys?
No questions, Your Honor.
No question. No questions, Your Honor.
Thank you. You may continue.
What are some of the day-to-day duties that you had as an analyst with the Florida Department of Law Enforcement?
Can we repeat that again?
What are some of the day-to-day duties that you had as an analyst with the Florida Department of Law Enforcement?
As a senior crime laboratory analyst, I am responsible for the examinations of firearms, ammunitions, fire components of the ammunitions, such as projectiles, span casings. Identification of the firearms, function check, safety check, and test fire the firearms. Conduct microscopic comparisons of bullets to bullets, cartridge cases to cartridge cases, to determine whether they were fired in or fired from the same gun or not. Serial number restoration, distance determination based on gunshot residue patterns, and many other related duties.
Did you indicate that the job duties included the analysis of shell casings for identification purposes?
Yes,
Would that be to identify the caliber of the ammunition and something in addition to that?
yes,
And are you able, when you look at a shell casing, to identify that shell casing to other casings fired if they're from the same weapon?
yes.
Can you tell the jury, I guess briefly, what is a shell casing?
A shell casing, or we call a cartridge case, is one of the four major components of a cartridge. Besides the cartridge case, the other components are the primer, the gunpowder inside the cartridge case, and the last component is the bullet or the projectile that is seated inside the cartridge case mouth. So the cartridge case is just one of the four major components.
Say you are in a controlled environment like your lab, for example. What happens if you are test firing a weapon with the projectile after it's fired, and what happens with the cartridge case?
Well, it depends on the type of action, the type of guns that was fired. If this is a semi-automatic pistol, the pistol is automatically eject. Its fire cartridge cases eject from the gun.
And if it's a revolver, for example, the other option?
A revolver do not eject the cartridge case out of the revolver after you fire that. Because the cartridge or the ammunition is loaded in the chamber of a cylinder. After you fire that cartridge case stays in the chamber of the cylinder. So when you see cartridge cases recovered from a crime scene, that is an indicative to a semi-automatic type of firearms and not a revolver.
In speaking specifically about semi-automatic firearms at this point, talk to me about what happens with the cartridge case from that, if any specificity can be given when it's fired.
A semi-automatic pistols utilize a device called a magazine. You load the ammunition into the magazine, then you insert inside the magazine housing of the pistol. You pull the slide to the rear, let go of the slide, and the slide will travel forward under spring pressure. As the slide travels forward, it strips a cartridge from the top of the magazine and insert that into the chamber. If the safety is off, all you have to do is pull the trigger, bang. Once it fires, the cartridge case automatically ejects out of the pistol. It's about 90% of the semi-automatic pistols eject to the right and slightly to the rear.
When you are talking about the percentage of where they eject to, is that in a controlled environment where the cartridge case would eject?
Yes, in a controlled environments, yes, it is pretty predictable where they are going to be landed.
And predictable to what degree? Is there like, would you say within 5 feet, 10 feet? Are you able to say typically in a controlled environment if you fire a semi-automatic where that casing would land?
Based on all my experience within the last 25 years, shooting guns, inside a shooting range, in general, for handguns, the cartridge case will land between 0 to 15 feet. For a long gun, such as a rifle, it will go further.
And are there factors that can be considered regarding where the cartridge casing will be located when the firearm is discharged?
Yes, it depends on the ground. For example, if the cartridge case is landed on grass, it's pretty much stay where it is. If it's landed on the street or on the concrete or the sidewalks, it will bounce a few times and then it roll a little bit and then come to a stop. If the ground is not level on an incline or on a slope, the cartridge case is going to roll down until it come to a stop.
Are there also considerations such as outside factors? So if, for example, a firearm is shot from a moving vehicle?
Yes, of course. If you fire a gun from a car, a moving car, then the cartridge case is going to spread out a lot more because the car is traveling. It also depends on the person that is shooting the gun. The person could be holding the gun in a normal fashion with the gun sights on the top. But then if you see a lot of Hollywood movies, people are holding the gun sideways. So that changes the directions of where the cartridge case is going to land.
I would like to ask you specifically about speed. Is that a factor that's taken into consideration in determining where they land? The speed, if it's in the vehicle with the example we just talked about.
Yes, absolutely. If the car is traveling, let's say 15 miles per hour, you fire one shot and the next shot you fire, well, it's going to be a little further down. So it's going to be spread wider.
And then third-party influences. So we already have talked a little bit about a roadway, for example. If there are other vehicles in the roadway, are cartridge cases an object that are able to be moved then by those vehicles or picked up then by those vehicles?
Yes. And if they are cartridge case on the street, they could be hit by cars. And also it could be people on the street could kick the cartridge cases. So yeah, those are the, some of the factors that influence where the locations of the cartridge cases are.
Now, specifically in your analysis of a cartridge case, can you tell us what it is that you look for when you're completing the analysis for comparing cartridge cases to each other?
Well, I'm looking for markings left on the cartridge case during the firing of the gun. When the gun fires, it will leave its individual characteristics, or what we call ballistic signatures, on the cartridge cases. And the area that I look at on the cartridge case are marks that were left there from the breech face of the firearms. Breech face spells B-R-E-E-C-H, breech face. Also, I look at the markings from the extractor, the ejectors. They all leave markings on the cartridge case from the gun.
And what is it that you can say as far as the uniqueness of the markings on the cartridge case?
They are very unique because every gun has its unique ballistic signature.
And that's left behind by what? How does that happen? How do the markings on the casings happen?
Well, when you fire a gun, the gunpowder undergo a chemical change. It changes from a solid, a powder, into a rapidly expanding gas. For a 9mm, the pressure in that chamber is about 35,000 psi, pound per square inches. The tire that is on our car is only 35 psi. So you're talking about 35,000 psi. That is a lot of pressure. So when you have two objects come in contact in extreme pressures, the harder objects will mark the softer object. The gun is made of steel. The bullet has a bullet jacket made of copper. It could be copper, brass, or aluminum, which is softer. So when you fire that gun, the gun will leave its ballistic signature on the cartridge case as well as on the bullet.
You spoke about the expanding gas when that pressure actually makes contact. Is that when the projectile leaves the gun?
Yes. That 35,000 psi that drive the bullet out of the cartridge case into the interior of the gun barrel, engage the rifling, then exit the gun barrel. For a 9mm, it has a maximum distance that it could travel. It's about a mile.
When that gas actually happens, when that contact happens and we see that gas and the projectile leaves the gun, is there something that happens visually when you see when the gun is fired?
Well, when you fire a gun, you will see muzzle flash. Muzzle flash is basically the high temperature, high pressure gas, the 35,000 PSI, expelled out of the gun barrel as the bullet leaves the gun barrel. It's a light. As well as there's a muzzle blast. The blast is the sound. Boom. Okay, it's pretty much like lightning and thunder.
Is there a difference in the muzzle flash that you can see visually or the blast that you can hear from a 9mm to, say, a 5.56 or .223 rifle round?
Yes. Now, during daytime, you might not be able to see the muzzle flash, but you definitely could hear the muzzle blast. At nighttime, you're going to see the muzzle flash very well, as well as the muzzle blast. Now, for a 223 or 5.56 millimeter, the rifle, it's going to be a lot louder, a lot brighter than a 9mm.
And you say brighter, is that the muzzle flash is brighter?
Yeah, the muzzle flash.
And when you're using the term brighter, is that visually a bigger muzzle flash that we see than a 9?
Yes.
Okay. Now, tell me what tools you utilize in comparing your shell casings, please.
We use a scientific instrument that called a comparison microscope. Basically, it's two microscopes combined into one. That has two stages. Each stage holds a specimen, a bullet or cartridge case. So we have two specimens, two bullets or two cartridge case. We compare them side by side under various magnification. 20 times, 50 times, 100 times is actual size. So we are looking at the marks at the microscopic level. These marks are invisible to our naked eye, but under the microscope, under the magnifications, you could see them very well. And we compare those markings.
And what do those markings actually look like when you have the images side by side?
Well, the markings that we see are, it could be parallel lines, could be diagonal lines, could be wispy lines, it could be dots, big dots, small dots, shapes, geometric shapes, irregular shapes. So we look at all those little tiny, tiny microscopic features, and we compare the pattern of one to the pattern of the other.
And for purposes of making an identification, do those tiny microscopic features need to be consistent from sample 1 to sample 2?
Yes. If all these microscopic features correspond to each other, that means the patterns of one to the pattern of the seconds has a common source, a common origin, and the common origins is the same gun that put their ballistic signatures on both patterns.
What is the range of conclusions that you can make as an analyst when you are analyzing ballistics?
Basically, we have 4 conclusions after microscopic comparisons. Identification, that means it is a match. Elimination, it is not a match. Inconclusive, I cannot tell you one way or the other. And the final conclusion is no value for microscopic comparisons.
Are the most definite findings from the options that you've just provided us identified or eliminated?
Can you repeat that again?
Yes. Are the most definite of the options you gave us inconclusive, no value, Identified, eliminated. Identified as a match, eliminated as not match. Is that
Yes.
right?
That is most definitive conclusion that we could get. It is either fire from the gun or not fire from the gun.
When we're talking about the components or parts of a bullet, what is a fragment?
Well, a fragment is a piece that was broken off from a hole or from a bullet.
Do you have a better probability in making your comparison for identification or elimination if you have the full projectile?
Absolutely. If you have a full intact projectile, you have more areas to work with. If you have a tiny little bullet fragments, there's not much you can work with, based on the amount of markings on the fragment.
Now, I just lastly want to talk to you about maybe something that may not be knowledge to everyone if we can. We have referenced 5.56 or 2.23. What is the relationship between those two things?
5.56 millimeters is expressed in the metric systems of measurement. The .223 is expressed in the English measuring system, which is expressed in inches. They are the same. 5.56 millimeter is equivalent to the .223 inch. It is your preference. Some people call it 5.56, some people call it 2.23. They are the same.
One measurement is just in millimeters and the other in inches.
Yeah, it's just a different measuring systems.
So if we see, for example, ammunition or packaging that says 5.56 and 2.23 on the box, they're referring to the same bullet.
Yeah, they are essentially the same ammunitions. It's just what the manufacturer calls it.
And
Now-
that's the measurement of the diameter of the bullet.
Yes, the 5.56 millimeter or the .223 inch express the diameter of the bullet as well as the diameter, the interior diameter of the gun barrel.
Did you, in this case, have an opportunity to analyze ballistics evidence by way of firearms and cartridge casings and projectiles?
Yes.
I am showing you what has been marked as State's Exhibit number 44. If you would take a look at that and tell me if you recognize that summary.
Yes, I recognize it.
And does this summary include the groupings by which you have concluded the linkage of all the ballistics in this particular case?
Yes,
Fairly and accurately?
yes, accurately.
And, Your Honor, at this time, the state seeks to admit States 44, the ballistics evidence summary exhibit.
Any objections? All right, 44 will be admitted.
No objection from anyone?
No objection.
Sir, do you recall the total number of cartridge cases you were asked to analyze in this case?
A total of 40 fire cartridge cases.
I'm going to try my best to put this on the screen for you if it will work for us today. I'm hoping circle means working. A total of 40?
Yes,
And were you asked to make a comparison as to the relationship between the cartridge cases that you received for analysis?
yes,
In the analysis that you completed, do you look at each cartridge case to determine the condition of the cartridge case?
yes,
And looking at the key over the screen to your left, there is no group 5, excuse me, as it relates to the cartridge cases here. What was the difference with the cartridge case that was your number group 5 that was determined?
Group 5 only contains one cartridge case.
And
So-
what was the condition of that cartridge case?
That cartridge case was damaged and it was crushed, flattened.
Now, if we're looking at just what we have on the screen here, this key, what are these groups referring to?
Can you repeat that again?
Yes, what does group 1 mean? Is that all of the cartridge casings analyzed in one group?
That's correct, yes.
And would that be all of the cartridge cases that ultimately you concluded were fired from the same gun?
Yeah,
Is that the case for all of the groups listed here on the screen?
yes,
And for groups 1 through 4 and 6, was there more than one item of ballistics evidence?
yes,
I'm showing you now what's been admitted as State's Exhibit 5. Do you recognize this item and these? If you could keep them clipped, it might help us to go a little bit faster if we can. Do you recognize this envelope?
yes, I recognize the envelope by the unit FDLU case number, the item number, and my initials or my handwritings on the outside of this packaging. Also, on every little small packaging, as well as on every single cartridge case, they all contain the FDLU case number, the item number, and my initial of my handwritings.
And so each envelope and then actually each casing that was collected itself, you're able to write on.
Yes,
And is this package, at least in State's Exhibit number 5, indicative of the 25 9mm casings that you analyzed in this case?
yes,
Your Honor, at this time, State seeks to introduce State's Exhibit 5 if not previously admitted.
Any objections?
No objection.
Hearing no objections, it will be admitted.
And then ultimately, did you also have an opportunity to analyze 15 5.56 casings, or 223?
yes. Again, I recognize the FDLU case number, the item numbers, and my initial of my handwriting on the packaging, as well as on every small envelopes inside this packaging, as well as on every cartridge case that is in this packaging.
And is that standard procedure for the Florida Department of Law Enforcement to annotate in that way on each of the items and package them individually like this when appropriate?
Yes, that is per the FDLE standard operating procedures.
Now I'm going to show you first Group 5. So when we talk about Group 5, I am referring to what's been previously admitted from State's evidence marker number 51. Group 5 is the group that is not reflected on the casing key here. Do you recall what ammunition caliber Group 5 was?
May I refer to my case notes?
Would it help you to recall?
Yes.
I apologize. Did you renumber the items once they came in from what the law enforcement officers would have made exhibit markers at the scene? Meaning you don't use the same numbers that we use for exhibit markers, correct?
That's correct, yes.
So this would have been your renumbered FDLE 1X, if that helps.
Yes.
Okay.
That would be, or correspond to the evidence marker number 51.
Correct, sir.
I'm sorry, Judge, 30,
51. And you had an opportunity to analyze this this casing from evidence marker number 51, is that correct?
That is correct.
And what, if any, determination were you able to make about the casing that was collected at that location?
As you can see, it is quite damaged. It's crushed, and it's very damaged. And the manufacturer of this cartridge case is by Hornady, spells Hornady, and it is a 9mm Luger caliber ammunitions. This manufacturer, Hornady, is different from the other 24 9mm casings.
This manufacturer of Hornady was different than the other casings located.
Yes,
And based on the condition of this particular casing, was this casing's condition different than the other casings than you analyzed as well?
yes, very, very different. Has a lot damage. The other casings are in pretty good conditions.
Now, as it relates back to what we were viewing as the grouping subsequent to group number 5. So if you need me to reference 5 again, I will, but that is the end of group 5. Group 5 was fired also from a different firearm than any of the other ballistics you analyzed?
That's correct. That was fired from different from the other groups, the other 5 groups.
Now, in your analysis, if we talk specifically about group number 1, please. Are you able to locate your notes for group number 1? Your A, starting at your 1A.
Yes,
Wonderful. In utilizing the key that we see on the screen before you here, are you able to identify the color associated with group number 1, please?
yes.
And, I apologize, go ahead.
Yeah, group 1 is indicated as red color.
And in your review of the summary, were you able to identify which numbers of casings were associated to group number 1?
Yes,
And were the items identified to group number 1 associated to evidence markers as well?
yes,
And are you referring to your renumbered chart, which is the numbers that you assign to each of the cartridge cases renumbered for what the evidence markers reflected?
yes,
Are the numbers reflected in red on the screen before you each of the evidence markers for which the firearm for group number 1 discharged these casings?
yes. All the cartridge case in group number 1 were fired in the same gun.
And how is it that you are able to correlate each of the casings to each other? Were they identified to each other?
Yes, they were identified to each other using a comparison microscope. That their individual characteristics correspond to each other. They have the same pattern, same ballistic signature.
You would not have been present on the scene to actually see the location of where each of these casings landed, isn't that correct?
That's correct, yeah. All my work is done inside a laboratory.
Can you explain for us how the casings that were 1 through 12, and I'm going to show you from evidence marker 6 if you want to reference your notes there, how were the casings collected from 1 through 12 different in condition from the casing collected at evidence marker 51 that we just saw?
They are in very nice conditions.
When you say nice, what is the texture of a fired casing if nothing else has impacted it and there's been no damage to it? What's the texture? Is it smooth or is it textured?
Oh, it should be smooth, unless it was, ran over by a car or something.
And when you view typically, bear with me, the head stamp on your ammunition or cartridge case, are you able to legibly see any information on the head stamp of a round, whether fired or live?
Yes, you could tell the manufacturer as well as the caliber of the ammunition. In this case, the manufacturer is Norma, spelled N-O-R-M-A, and the caliber is 9mm Luger.
Were you able to make a comparison to all of the items that we have just put up for you as it relates to group number 1?
Yes,
And your conclusion as to group number 1 depicted in the red markers related to the evidence marker numbers from the scene
yes,
was what?
they were all fired in the same gun.
Did you repeat that same process with the rest of the ballistics?
Yes, with respect to the other groups.
Now, I want to be clear, when you receive the ballistics, do you know what groupings they're actually going to go into?
No, I cannot do that until I conduct microscopic comparison to group them based on the individual characteristic, based on their ballistic signatures.
I will have you look now to group number 2, please. Should start with your FDLE marker 1H.
Yes, this cartridge case are under group number 2.
And what was your conclusion as to the ballistics from group number 2 at markers 10, 11, 29, 41, and 46?
They were all fired in the same gun, but different from the group number 1.
Group number 2 would be the next firearm.
Yes, another firearm.
And again, the same thing on these casings where we see the condition is smooth. Is that correct throughout your analysis of all the casings? I won't keep switching back and forth for you, but essentially you were able to identify the head stamp and the condition of the casing was smooth again.
Smooth and no damage.
Now, the damage, when we're talking about it, are you talking about that pebbling damage? Because this one, it appears to be damaged, at least to a layperson or a regular person seeing it. Why is this damage different?
Okay, this one is damaged. It could be someone step on it. It could be that when it was eject out of the gun, it come in contact with the ejector port of the slide that caused that damage.
But this was different in nature than what we saw from evidence marker 51 or group 5.
Yes.
And what is your conclusion as to all of the ballistics evidence as it relates to group number 2?
They were fired in the same gun and different from the other groups.
I will move you now to group number 3, blue in color. What can you tell me as it relates to group number 3, starting with your number 1K and our evidence marker 13, please?
All these cartridge case under group number 3, they were all fired in the same gun and different gun to the other groups.
Now, for this particular set of casings, were you ultimately from law enforcement provided a weapon to analyze?
Yes,
And how does that differ from what we've seen thus far?
Once we have a firearms for examination, we will compare all the cartridge cases to that particular gun to determine whether that gun fire any of the cartridge cases or not.
In this particular case, were you provided with a Taurus 9mm pistol to analyze for comparison purposes?
Yes, I did.
Prior to that, had you already completed an analysis of casings 13, 14, 15, 16, 27, 45, 49, and 50 to each other?
Yes.
Were these casings identified to each other?
Yes, they were.
I'm showing you now what has been marked as states 29A through I, if you would take a look at those photographs.
Yes, I recognize this, this firearm based on the serial number.
May I have those? Thank you. And when you received this firearm for testing some months after the comparison of the casings to each other, do you operate your own testing?
Yes. It is one of our procedure that once we receive a firearms, we have to identify the firearm by the manufacturer, the caliber, the model, the serial number. We have to conduct a function check, safety check to make sure all the safety is working properly. And then we have to test fire the firearms to determine whether it's functional or not. And the test fire that we took, the test fire bullets and the test fire cartridge case, and then they will, we will use them to compare against the evidence bullets and evidence casings.
Your Honor, at this time, the state seeks to admit states 29A through I.
Any objections?
No objection.
No, Your Honor.
All right, hearing no objections, it'll be admitted.
I am publishing for you states 29E. Do you recognize the firearm depicted in states 29E or 29B? I believe you indicated by serial number.
Yes.
Is this the firearm that you tested in the months after the comparison was made to the original casings?
Yes.
And what was your conclusion as to whether this firearm discharged the rounds or left behind the casings from group number 3?
Yes, the cartridge cases in group number 3 was positively identified to this pistol match. It's a match. That
Now-
means that this pistol fired all the cartridge case in group 3.
And were all of the cartridge cases that were tested for group 3 eliminated from any of the other groups? No other gun could have fired group 3, and those in group 3 were exclusive to what you were provided from this scene.
Yes.
Were you also provided a projectile for analysis related to the test fire of this firearm?
Yes.
And did you make a comparison to that projectile as it relates to the projectile recovered from the vehicle of the victims in this case?
Yes.
What was your conclusion as it relates to the projectile that was provided to you from the vehicle to this particular firearm?
That projectile was identified as having been fired from that Taurus pistol you just saw on the screen.
Now, when we look back at group number 3, you had an opportunity then for this blue group to identify a firearm to the casings left behind.
Yes, the auto cartridge case from group 3, as well as that projectile recovered from the car, they match the gun, that Taurus pistol.
Whereas before, what we've looked at are the casings that match each other. You have not been provided a firearm to confirm to the casings in groups 1 or 2. Only can match the casings to each other.
Yes, without a gun, I can only match the casing to each other. But with the gun, I could compare all the casings to the gun.
Is there any difference in the comparison as it relates to the casings being identified to each other versus the casings being identified to the firearm? Does it change anything about your identification of the casings to each other?
Well, essentially, the comparisons is the same methodology. You have 2 samples, evidence to evidence or evidence to a test. It's the same process. I'm looking for the ballistic signatures on the casings. If the patterns of individual characteristics correspond to each other in agreements, their ballistic signatures are the same gun.
And looking now to the casings from group number 4, how many casings were identified from group number 4 to each other?
There were 2 casings in group number 4.
Is that at evidence markers 43 and 44 as depicted on this diagram?
Yes.
And did you subsequently, in this instance, also have a firearm by which you were able to make a comparison directly at a time later than your original identification of the casings to each other?
Yes.
And so what's been identified in green there are the 2 that you have confirmed were identified to each other at evidence markers 43 and 44.
Yes. 43.
Oh, I apologize.
43 and 44 were fired from the same gun.
Sometime thereafter this initial identification, were you provided by law enforcement with a firearm that has been previously admitted as exhibit number 31A and B, so a firearm and a magazine from law enforcement for identification?
Yes.
And this firearm here was previously admitted as having been identified to one of the defendants. Do you have any information about who the weapon belongs to or anything like that?
No, I do not.
Did your conclusion include any kind of identification? Yes, it's identified to Mr. Denson's gun.
No. I don't know whose gun it is. All I do is compare the evidence cartridge cases to the test fire cartridge case of this gun.
And when you received this gun for analysis, please tell me how many live rounds of ammunition were also provided with this firearm.
I received 14 unfired 9mm Luger caliber cartridges.
Are you familiar with a Taurus 9mm Luger pistol and the stock magazine that it is equipped with?
Yes.
How many rounds does a stock magazine on this weapon hold?
The magazine that's submitted with these pistols has a capacity of 16 cartridges.
16 total cartridges?
Yes.
Is that to include the magazine and a round in the chamber?
No, that would be 16 plus 1.
If you load this magazine fully and insert it into the firearm, as you did with your test firing, how many discharges does it take to leave 14 rounds in the magazine?
Well, if it is fully loaded, 16 plus 1, subtract 14, 3.
If there's nothing in the chamber and you have taken the firearm from the box and a fully loaded magazine and entered it into the firearm, how many discharges to be left with 14 in the round?
2. Oh, can you repeat that?
Yes, so the firearm, when you receive it, is not loaded.
That's correct. It has to be offloaded for safety purposes.
And a full magazine holds,
The whole full magazine holds 16,
so in discharging that weapon twice,
then we'll leave 14.
did you, in your comparison, to identify or confirm that this firearm fired the rounds left at these evidence markers, also impound the test fires from that weapon?
Yes, I recognized the packaging by the FDLE case number, item number, and my initial, my handwritings on the packagings, as well as on each one of my test fire bullets and test fire cartridge cases.
Your Honor, at this time, the state seeks to admit states 32.
No objection.
Okay. Objection.
Hearing no objections, that will be admitted.
Sir, are test fires actually shot in a controlled environment?
Yes, this test fire was shot in our shooting range, which is an indoor facility that contains a big water tank. I use laboratory ammunitions, and I use them to test fire the gun.
In this particular case, you used these test fires, and what did you shoot into?
I shoot the bullet into a water tank.
I will show you first the casings that you identified as the test fires that you shot from this weapon. Is the ammunition that you use for your test fires that which was provided with the firearm, or do you use a standard ammunition that's with the agency?
With our laboratory, with our agencies.
And do you also shoot a variety or different types of ammunition, at least brands or maybe materials, so that you're able to see different markers to make sure that the ballistics comparisons are accurate?
Yes.
Is that why we see essentially different colors of ammunition here?
Yes.
Now, I want to show you specifically the projectiles from those test fires, please. Your item 6.1. Do you recognize that?
Yes.
In the controlled environment, you had test fires which appeared in this manner. What is that test fire? What's happened to that projectile?
This bullet design is called jacket hollow point. The jacket hollow point, essentially, the nose area is hollow. The purpose of that is for expansion. So when the bullet hit an object, a body, the nose area of the projectile will expand, which cause a bigger hole to the body.
Now, in showing you the second projectile here, that looks a little bit different when you're talking about expansion. Why is this second item different?
It's different manufacturer. Both of them called jacket hollow point. Both are designed for expansions. One manufacturer designed so that it expands more than the other.
And for example, as we talked about fragments earlier, are these pieces, had they not remained attached to this projectile, did these pieces of metal file off the firearm when it's fired? Or the projectile when it strikes something?
Yes, there's a potential for small pieces of bullet jacket or even the bullet core to fragmentate it.
So in addition to the projectiles, we see a collection of, for example, fragments. But if you're asked to compare just this little portion here that I'm pointing to on the right of this one, does that make things more difficult in your comparison?
Yes, it is very difficult because you have a very limited area to work with.
Lastly, from your test fires, can you explain to us why this projectile that I'm showing you differs in any way from the earlier two?
The design of this bullet is called full metal jacket. As you can see, the nose area is solid. The purpose of this design is for penetrations. The full metal jacket will penetrate through and through your body. Whereas the jacket hollow point, there's a high chance that the bullet will stay in the body.
You ultimately did use the test fires that I've just presented to you to make a conclusion as it relates to the firearm that's previously been identified as belonging to James Denson.
Yes.
And what was that conclusion?
Are you referring to the cartridge cases?
To the cartridge cases and that were located on scene from 43 and 44, and obviously your test fires from that weapon, comparing them to each other.
Yes. The cartridge case, evidence marker 43, 44, they were identified to the Taurus pistol that we just saw.
This one in the box, not the photos?
Yes, the one in the box.
Okay, thank you. And then lastly, did you have an opportunity, we've talked about group number 5, so this is green group number 4, yes?
Yes.
We've talked about group number 5, which is another casing, you don't know where it is, but it's evidence marker 51.
Yes.
Great. Now let's talk about group number 6. What in any way was different about group number 6 during your comparison from what we've just seen as groups 1 through 5, please?
The cartridge case of group number 6 has a different caliper than the other 5 groups. The caliper of this group is 5.56 by 45 millimeters. The other 5 groups are 9 millimeter caliper. All these cartridge cases were identified as having been fired in the same gun or same firearm.
So the same firearm produced all of these cartridge cases.
Yes.
What type of firearm discharges 5.56 or the different measurement 2.23, which it should be .223, shouldn't it, up there
Yeah.
on that chart?
Yeah, it should be .223.
Okay. With that correction, though, what type of firearm discharges this type of ammunition?
This type of ammunition, the 5.56 millimeter, was designed for rifle, a long gun, a rifle.
A rifle?
Yes.
And is the rifle the type of gun that you indicated would give us a bigger muzzle flash than a 9mm weapon?
Yes.
Why is the rifle muzzle flash so much bigger or brighter?
Because the 5.56 millimeter is much more powerful than the 9 millimeters. That means there are more gunpowder that give you that higher velocity and the bigger bang.
you had an opportunity then to analyze the casings that were identified to each other from this rifle round, I presume?
Yes.
And I'm going to show you what has been marked as State's Exhibit number 4, if I can, on the screen. Can you see that okay?
Yes.
So I'm showing you marker 20 from that exhibit, same small envelope that you are applying to all of the others.
Yes.
And tell me how this round is different than the other shell casings that we've been seeing today.
As you can see, it is longer. For rifle ammunitions, the cartridge case is longer.
What does it mean to be longer? Is there something different about the ammunition itself?
Well, it's longer, that means you could put more gunpowder in it.
And does that result in the brighter flash?
Yes.
And so you did that with each of the casings from that same number, is that right?
Yes.
Or that same group number?
Yes.
And all of these, again, have your identifying marks on all of the rifle casings that were fired?
Yes, they all contain the FDA case number, the item number, and my initial or my handwriting.
I'm going to switch you back to your grouping chart here, if you can, please, over your shoulder. Are all of the rounds that are depicted at the bottom listed by evidence marker number 17 through 23, 25 through 28, 30, 35, 38, 42, and 48 identified to each other as being fired from the same round? From the same firearm.
Yes, from the same firearm.
And were you provided, or did you ever receive any kind of firearm for confirmation like we had in States 31 with the Taurus firearm I showed you in this box?
No.
But your conclusion was, without having even the rifle to identify, that you could identify at least the casings to each other?
Yes, they were all fired in the same firearm.
And as it's depicted on the chart before you, had they all been documented by color in the chart?
Yes.
And is that the orange rounds, the rifle rounds that were fired, at least identified by evidence marker here?
Yes.
Ultimately, did you have an opportunity to view in its entirety a composition of the ballistics evidence in this case on the scene diagram as it's depicted in the summary exhibit you're looking at? So all of the colors on one chart.
Yes.
Now, when we look a little bit closer at the 5.56 rounds, or 223 rounds, correction again, right? It should say .223, not 2.23 for the measurement of the diameter of the ballistic.
Yes.
Now, looking at that grouping, do you recognize this closer chart?
Yes.
Was this also respective of the casings located that were related back to group number 6, the rifle?
Yes.
So 25, 26, 28, et cetera.
Yes.
Okay. When we look to the coloring for the rifle rounds of orange, is there any difference in any of those casings that you analyzed that would indicate to you that there could be another rifle that was fired?
No.
And in 42 and 48, as depicted here in orange, were those also identified as having been fired from the same rifle on one of our scene maps?
The same firearm, yes.
Now, lastly, did you draw a conclusion as to, or that was your conclusion, excuse me, as to all of the listed ballistics for where the, or which of these evidence marker numbers correlated to the rifle rounds?
Yes.
And is that as depicted here on these scene diagrams by color in orange?
Yes.
Now, I'll go back to my earlier question. I think I got a little ahead of myself. Ultimately, would you have an opportunity to see the diagram itself with each by casing key? I've put it up here for your refreshment, where all of the ballistics were labeled in the scene diagram, at least those that you received for testing, with the exception of group number 5, item or evidence marker, excuse me, number 51.
Yes.
And looking at the scene diagram number 1 here over your shoulder, is this map here consistent with the colors as provided in our key from the scene for the ballistics at this location?
Yes, pretty accurate.
I know the maps themselves may not be to scale, but the colors coordinated with each of the item or evidence marker numbers are consistent with your findings.
Yes.
Map, finally, number 3, also consistent.
Yes.
And in totality, when I give you the key itself here in the bottom left, is this accurate as to the ballistics evidence left behind at the scene? Not as far as your correlation to the scene, but as far as your results with the groupings of each of these firearms?
Yes.
Your Honor, may I have one moment?
Yes, ma'am.
Your Honor, may I have just one more moment?
Yes, ma'am.
Oh, okay, perfect. Thank you. No further questions, Your Honor.
Cross?
Good morning, Mr. Kwong. How are you?
Good morning, sir.
Mr. Kwong, you were testifying on direct examination about muzzle flash. You recall that line of questioning?
Yes.
And I want to ask you again, just so I understand. Did you give a description of what a 9mm muzzle flash would look like at night? Because I was having a hard time understanding or a hard time hearing it.
All I said is that because the rifle ammunition's a lot more powerful than a 9mm, which is a handgun. So I would expect to see the muzzle flash from a rifle would be bigger than the muzzle flash of a 9mm.
And so you were only suggesting to us and describing the difference between one and another, correct?
That's correct, yes.
And your description would be that a 5.56 or a rifle discharge or a muzzle flash would be brighter. Is there anything else that you would think would distinguish the two?
Well, it's brighter and also bigger.
Okay, bigger meaning longer, meaning wider, as you visualize it, as you see it.
Larger and also longer.
Would it take a certain form as you see it visually?
Well, yeah, you could see it visually at nighttime.
Okay, and what would it look? What would it look like?
It's a bright light.
So, moving on to your testimony on State's Exhibit number 44, which is your charts. I'm going to show you one of the All right, we're good. The 9 casings that are displayed in this group 1 are located within the first third or so of the total 879 feet that exist from the start at North 45th Street to the end where the vehicle came to rest, correct? You would agree with me?
Yes,
And that would constitute, if simple math tells you, somewhere in the neighborhood of 300 feet. If it's approximately a third.
yeah, a third of it, yes.
And when you look at those casings, there's no way to determine whether those 9 casings, how far they could have been displaced, whether it be from the ejection process itself or from any contact with passing traffic, correct?
That's correct, yeah. And also, if the car is moving, yeah, it also taking that into factor.
Okay, so the movement of the vehicle, the ejection process itself from a semi-automatic weapon, as well as any traffic that it may come in contact with, correct?
Correct. If there are other cars on the road, they could have pushed the casing further.
Nothing further, thank you.
No questions.
Good morning, Mr. Kwan. Nice to see you again.
Good
So
morning,
I want
sir.
to talk to you about the fact that there's 2 Taurus 9mm firearms that you had the opportunity to analyze in this case, correct?
Yes,
All right. So the first one is as described in States 29, where you had the pictures. Okay, remember looking at the pictures earlier?
yes, on the photographs, yes.
Okay, and that's the one where you connected it to 8 casings and 1 projectile, right?
That's correct, yes.
And that was a projectile that was found within the vehicle.
That's correct.
All right, and then States 31A and B is actually what we have with us here,
Yes.
right?
Yeah, the gun in the box.
Okay, so it's 2 different firearms that we're discussing, but they're both Tauruses.
Yes, they are from the same manufacturer, Taurus, as well as same caliber, as well as same model.
And these are the casings that we're talking about at evidence marker 43 and 44 towards the west side of the crime scene, correct?
Yes,
So when you test fired, remember when you were showing us your test fires earlier from State's Exhibit number 32?
yes,
You used hollow points and you talked about fragments that happen as essentially the projectile is expelled, correct?
yes.
Would you agree with me that those fragments are not unique to that particular firearm?
Well, it depends. What do you mean by that?
When you have other hollow point bullets from other guns that you fire, okay, they are going to fragment in that same manner as the test fires from State's Exhibit 32. It's not unique that only this firearm is going to cause a hollow point bullet to fragment.
Yes,
So you agree with me?
yes, I
Oh.
agree with you, yes.
Okay. And earlier when you were discussing the capacity of the firearm, okay, State's Exhibit 31A and B, talked about the difference between when something is fully loaded versus just having the magazine capacity. Could you explain that to us, please?
Well, the full capacity is fully loaded magazine plus one in the chamber. So when it is fully loaded, that means whatever the capacity of the magazine plus the one in the chamber.
So what an individual would have to do is, they would have to insert the magazine into the firearm, they would have to rack the slide, causing a bullet to go into the firearm, then they would have to eject the magazine, put another bullet in, and then insert the magazine again for it to be fully loaded, correct?
That's correct. You described it better than I could.
I don't know about that, sir. But what I would ask you, though, based on your expert opinion and based on your training and experience in this area, should this jury take anything away based on the evidence that you've had to review about whether or not the whether or not the firearm in State's Exhibit 31 was fully loaded or anything like that?
I don't know.
Can you say anything about who is in possession of 31 as far as their actions on that night, whether they had the gun fully loaded, whether they had to chamber a bullet or anything like that?
I do not know that.
Okay, thank you, sir.
Anyone else?
Good morning, Mr. Kwong.
Good morning, sir.
You've identified shell casings in group number 6 as belonging to a 5.56 or a 2.23, is that correct?
That's correct.
All right. Were you able to identify those shell casings to a particular brand of weapon?
No, I cannot.
And were you able to do the same with the 9mm? Were you able to identify the shell casings on the 9mm to a particular brand of weapon?
No, unless I have the gun.
Okay. You have to have the actual firearm that discharged the casings in order to make a positive identification. Is that accurate?
That is correct.
Okay. And obviously, Mr. Wong, you have no idea who discharged the firearms that produced the casings, correct?
That's correct. That's
thank you.
beyond my expertise.
Thank you. I have no further questions.
I'm sorry. No,
Good morning, Mr. Kwong.
Good morning, ma'am.
So the examination that you do is strictly limited to ballistics, is that correct?
That is correct.
There are other areas of FDLE when you were employed there that would do potentially other latent examination like DNA or fingerprints, things like that.
Yes, we have other forensic sections.
But you would not do that.
No, I was not trained, and I'm not allowed to, and I won't.
The guide that we have in States 44, the different groups, they're color-coded, and the colors in A and B appear to be a little bit similar on the page, is that right?
Yeah.
Okay. When you did the examination, you were talking about Group 5 that's not included in this exhibit by the state. But Ms. Ismer showed you the casing itself and the damage that was on it.
Yes.
Okay. But that damage didn't prevent you from doing your examination to determine that it was fired from a different firearm.
No, it did not, because that casing still contained the ballistic signature from the gun that fired it.
So although it may have presented differently, you were able to do the same type of examination that you were on the other casings that we saw.
Yes.
Group 3, that firearm that the casings were grouped with, we see this in this page that's annotated in blue. Is that right?
Yes.
And this is the one that you said you had a firearm that's at the bottom of this that you tested to those casings after you grouped them together.
Yes.
So the first thing you're doing is you're taking all these casings and you're making your evaluation of what type of casings they are, and then you connected them to each other, if you could.
Yes.
And then this one and the other group that we talked about, that Mr. Fischetti was asking you about, was the other one where there was a firearm connected to those particular casings.
Yeah, there was the gun on the photograph.
Were there firearms connected to any of the other casing groups?
No, they were not.
And this 9mm Luger with the serial number, the ABG 655998, you don't know where that came from, is that right?
Yes, I do not know.
The law enforcement just submits firearms to you and you do your part of the examination.
Yes,
And as far as where these casings may have been located on this map, you're not ever going out to the scene itself.
no, I do not go to the crime scene.
And there's some of these casings in this diagram, like this group, for example, that has numbers that are earlier in the grouping, and then there's numbers that are highlighted that are later on in the grouping as far as the numbers go. Do you understand my question?
No, I do not.
Okay. There's evidence markers in this one where it's 13, 14, 15, 16, and then there's a 27, and then there's a 45, 49, or 50. So they're spread throughout the casings that we're seeing in this group.
Yes,
Okay. And this is the firearm in the group of casings connected to that firearm that you also were able to connect to a projectile that was located inside of the vehicle?
yes,
And that, again, the projectile being located inside of the vehicle, that's what law enforcement indicates to you is where that was recovered.
yes, there was information given to me by the agency.
If I could have one. In this colored map, where we have all of the casings and the key, I'm going to zoom in specifically to 10 and 11. Because in this map, the differences in the color are a little bit harder to see. Would you agree between that fuchsia color and the red?
Yes,
Okay, so 10 and 11 are part of group 2, not part of group 1, is that correct?
that's correct, yes.
So although the color in this longer map that has everything, those may look similar to the ones around it, the 10 and 11 are different from 12, 9, 52, 8, and these other ones.
That's correct.
Nothing further.
Anyone else? Redirect?
Just very briefly, Your Honor. Mr. Kwong, are you able to confirm for me that the firearm depicted in the photographs that you observed with the serial number ending in 5998 was provided to you under a different or separate agency report number than the rest of the ballistics provided in this investigation?
Yes,
And is that as documented on your report dated November 24th of 2021?
yes,
Had the rest of your ballistics examination of all of the cartridge casings from the scene been completed before that date?
yes,
And this gun was subsequently submitted to you from the law enforcement agency under a different case number?
yes.
Nothing further, Your Honor.
May this witness be excused?
Yes, Your Honor.
You may.
Thank you, you're free to go, sir. Thank you very much.
Thank you, Your Honor.
All right, ladies and gentlemen, it's a good time to take our morning break, so court will be recessed for about 10 minutes.
All rise for the jurors.
Jury's left, y'all may be seated. Thank you, sir. All right, court will be recessed for 10. I have a question for the state.
Yes, sir.
Just for my own editor. Were 2 live rounds found, one in a car, one on the street, or just 1 live round?
One line.
Gentlemen, have a seat. Thank you, ladies and gentlemen. Welcome back. Sorry for the delay. Were you able to follow the court's instructions? Now, I know I said 10 minutes, but you got 8 lawyers and a judge all in one room. You know we're going to find something to do. So while you were gone, they were actually doing some things that are going to save some time on the back end, and we got some ducks in a row, and now we're ready to press forward. I appreciate y'all's patience. State whenever you're ready.
Yes, Your Honor. Say, recall Detective Chris Celaya.
He's still under oath. Thank you. Welcome, Your Honor. Mr. Terry, whenever you are ready.
Yes, Your Honor. Good morning, Detective. You're still under oath from yesterday. Detective, we called you back today. We have just now concluded testimony from a firearms examiner in this case. So I want to ask you some questions regarding part of that. Detective, at Tampa Police Department, do you all have a NIBIN unit or a unit that identifies when a gun is obtained that may be related to another case?
Yes, we do.
And kind of how does that work? If you can just sort of explain just sort of generally how it works for the
Well, we
jury.
have an in-house specialist, a couple of them, I think. Sarah Price is one of them. And what they do is, like, if a casing is found on scene, the images are uploaded into a database. If firearms are recovered, they will go take these firearms and test fire them, and then based off of the test fire casings, they upload them, and then they analyze it.
Okay, so it's sort of a way of making a presumptive match?
Correct.
Okay, so it doesn't necessarily mean that the firearm was fired. You have to send it to FDLE to further confirm whether or not that is in fact a firearm that was used in a separate case.
Correct.
All right, Detective, did there come a time where you received notification that there was a NIBIN hit regarding a firearm that had been obtained in a completely separate matter?
Yes, it was.
When was that?
It was on November 10th, 2021.
Okay, so this was at least a month or so after these defendants had already been arrested?
Yes, it was.
Okay, and this firearm came in on a separate case, on a separate arrest?
Yes.
Who was the individual that was arrested in that particular case with that firearm?
It was Raheem Bryant.
Raheem Bryant. Okay, now when that firearm was obtained, what did you do when you received notification of the NIBIN connection? What did you do at that point?
I went with the case agent that was working the case in which that firearm was recovered in, and I went and I spoke with Mr. Raheem Bryant at where he was at.
Okay, so you spoke with the individual who was arrested in possession of the firearm?
Yes, I did.
And I'm showing you what's already been introduced as State's Exhibit 29D behind you. Does that appear to be the firearm you collected on that in November?
Yeah, I mean, I didn't collect it, but yes.
Or that you sent to the Florida Department of Law Enforcement for analysis?
Correct, yes.
Okay, that's right. I realize you didn't connect it. In speaking with Mr. Bryant, did you later go back, so you knew what Mr. Bryant looked like, Raheem Bryant?
Yes. I mean, I was just conversing with him, having an interview with him, and, I had looked at extensive video, obviously on this case, from the Chevron, from the pawn shop, and at no point in the videos did I witness Mr. Bryant in there.
Okay, so you did in fact go back through, after meeting Mr. Bryant, after seeing him, after knowing what he looks like, you went back through and reviewed everything, and there was no connection between Mr. Bryant in that scene on that day?
Correct, yes.
All right. And you also spoke with Mr. Bryant about how he obtained the firearm. Would that be accurate?
Correct, yes.
All right. Did you find any connection or any reason whatsoever to arrest Mr. Bryant for any connection to this case?
No, not at all.
Judge, I don't have any further questions of this witness.
Cross-examination? Anyone?
Morning, Detective.
Good morning, Mr. Gonzalez.
Did you seek to identify every single person that traveled in, out, and amongst the gas pumps at the Chevron from the late evening hours all the way until this incident was over?
You could see a lot of the video. I mean, I've watched a lot of it. you could clearly see kind of who's coming and going throughout the day. You can also see that clearly, like who's entering the first vehicle, who's entering the third vehicle, and I could tell you that that was not Raheem Bryant, with 1,000%.
You haven't been able to identify individuals that get into the second vehicle, though, correct?
I believe I have a belief of who they are. I suspect of who they are. They appear to be them, but none of those individuals appear to be or were Raheem Bryant.
What about the fourth individual in that
You talking about the driver?
second vehicle?
Are you talking about the driver?
Yes.
The driver, like I said earlier, I believed it was Maxwell Bedward, based off of the kind of the car that he was driving earlier. I couldn't say definitively, but it was, I believe it was him.
I don't have any further questions.
No question.
Nothing else to Mr. Denson.
Nothing from Mr. Thompson, Your Honor.
Good morning, Detective.
Ms. Bradley?
You said that you received this NIBIN notification on November 10th of 2021. Is that correct?
Yes, that's when I became aware of it.
And the arrest of Mr. Bryant for possessing that firearm was on November 7th of 2021. Is that correct?
Correct.
So it took some time between them retrieving that firearm, doing a fire, putting it in the database for it to connect to this case.
Correct.
And you said that that's a presumptive match, the NIBIN correlation, but that can be confirmed by FDLE.
Correct.
And in this case, it was confirmed by Mr. Kwong at FDLE.
Yes,
Well, you're,
I believe so. I mean, I took the firearm to FDLE for analysis. I don't know exactly who it was that analyzed it, but
okay.
yes, it was correlated to the casings on scene matched that firearm.
But as the lead detective, you get those reports, right?
Yes,
And you got the FDLE report that confirmed what the NIBIN correlation presumed.
correct.
As far as Mr. Bryant, can you tell us what he looks like?
He looks, I mean, I have a good looking photo of him. I mean, he's a black male. And I don't know how descriptive you want me to be. I mean, I don't recall off the top of my head exactly what he looked like. I mean, I looked at him when we were there. I looked at all the videos. I don't have his photo in front of me, his booking photo, but it's very consistent with, you know, the photo that he had when he was, you know.
Do you remember how tall he was?
Not off the top of my head.
Or how old he was at the time?
I believe he was like mid-20s.
Did you collect his phone or do any download of his phone?
No.
And when you were testifying earlier, you said that second car, it pulls up and then quickly, after some other people get inside of the car, drives off.
Correct.
So you don't know who might have been inside of that car already when it pulled into the jet.
You see the people that get in the car, but you don't see anybody exit the vehicle.
Right, so if someone was already in the car and then others got in, you wouldn't see those people because they don't exit the vehicle at that time.
I think it's a fair statement.
Nothing further.
Redirect.
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Hearing nothing, no objection from the defense, you are free to go. Thank you. Thank you. May I call your next witness?
The state calls Benjamin Morris.
How many more? Come on.
Just wanted to, thank you.
Can you raise Raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
Whenever you're ready, Counselor.
Good afternoon, sir. Would you state and spell your name for the jury?
It's Detective Benjamin Bors. Last name is spelled B-O-R-S.
Where are you currently employed?
I'm employed with the City of Tampa Police Department.
And what do you do for the City of Tampa Police Department?
I am assigned to the Internet Crimes Against Children and also the Digital Forensics Unit.
What's your title there?
I am a detective.
And what is your duties day-to-day in the units that you work in?
We are part of the task force, like I mentioned, which is the Internet Crimes Against Children. So a portion of my job is to investigate crimes regarding the child exploitation that occurs online or any cyber tips that comes in. And then the second part of my job is to do digital forensics, primarily for either those investigations or for investigations with the police department for like cell phones, computers, vehicles, hard drives, video cameras, anything like that.
When you say you do digital forensics, can you tell us what that means? What does that look like?
The short answer to that is anything that can store digital media, such as a cell phone, a computer, an SD card, a hard drive. My job is to recover data from those devices.
And how do you go about doing that?
It's different in every scenario, but with cell phones specifically, we use software, and in this case specifically, we used Cellebrite or Graykey are the two softwares that we typically use.
When you said this case specifically, were you asked to either complete an extraction or review an extraction from several devices in this particular case?
Yes.
And tell me what it looks like to actually complete the extraction of a device.
For the devices that I did, we use a software called Graykey. So what you do is you plug that device in, and if we don't have passcodes to the phones, depending on what I would refer to the state of the phone, and the state being that if you have a phone that is unlocked but has not been turned off, meaning that the passcode has been entered at least one time after the phone has been powered on, it is in an AFU state, which stands for an after first unlock. If a phone has been powered off and the phone has never been turned on, that's considered a BFU, which is before first unlock. So if you ever used a cell phone before and you turn the phone on, you will see like Face ID or the passcode will say that you have to enter the passcode to enable Face ID after a phone restarts. So for us, it makes a difference on the data that comes off the phone depending on the state of the phone. So if we don't have a passcode, we plug it into the software, and in this case, we would get an AFU extraction, which is the after first unlock extraction.
Do you have some training or experience that you're utilizing in actually pulling these extractions or working with these electronic devices?
Yes.
And what is that?
I've attended multiple courses through NW3C, which is more of the basic courses on recovering data or interpreting data. And then I've also taken courses with Cellebrite, which is one of the companies I just mentioned, and then Axiom as well, which is the parent company that actually owns Axiom Magnet, Axiom Graykey, and then I have forensic training in Barreto, which does vehicle forensics for the infotainment systems. And then I went through IASIS, which is specific. It's like a 6-month training course over the recovery of data from computers or file systems, and it is a training that goes over the different file systems that exist.
A lot of the names that you mentioned, Cellebrite and Axiom, all of those, are those softwares that you utilize in actually obtaining the extraction from the phones themselves or devices themselves?
Both, extracting them, and then also they sell the adjoining software to actually parse the extractions.
Now, you mentioned a Cellebrite. Is that the program, like what we would use a Word document to type a letter? Is that the program that you use to review the contents that are extracted from the device?
So Cellebrite's the name of the company, but Physical Analyzer, it does exactly that. It takes the physical file that's extracted from the device and then analyzes it. And then the easiest way to explain it is it doesn't turn it into a Word document, it turns it into a program that allows you to interact with the devices on it. And then from that program, you can then generate reports to specific artifacts or specific files from the device.
And when you are talking Cellebrite, does that have anything to do with cell site? We've heard a little bit about cell phone location data and cell site information. Are those two things related in any way?
No, not in this case. I'm not sure if they sell a tool that does cell site analysis, but for me, I use it to interpret cell phone extraction data.
And that would be an extraction from the physical device that you actually received, at least in this particular case.
Or something that we receive from like a third-party company. So if we receive something from, we'll say, Apple, like a cloud return, you could also use that same software to parse out the returns from Apple.
Are you able to differentiate between the two? So when you see an extraction that's from a physical device versus a return from, for example, a search warrant to Apple?
Yes.
In this particular case, did you have the opportunity to analyze data from a device which has been previously identified as belonging to Mr. Hammond in agency tag ending 539?
Yes.
And along with the physical device extraction, which, did you complete that extraction yourself?
I did.
Along with that extraction, did you have an opportunity to review the Cellbright extraction report from the iCloud return?
Yes.
So do you work in your agency with other detectives who are also qualified to pull these extractions, or are you the only person?
There's multiple detectives or officers that do it.
And depending on whoever plugs the phone in, is that the person who does, quote, the extraction, essentially,
Yes.
of the data? Do you have access to the data, whether you have, plugged the device in and started the extraction or download process, or whether another person with your agency or detective in your same unit did it?
Yes, I have access to it.
And have you had an opportunity to review the contents from the iCloud return for Mr. Hammond's device as well?
I have.
I'm showing you now what's been marked as states 35. Would you take a look and let me know if you identify the items depicted therein?
Yes, the first photo is actually the photo that I take when I initially get the device, and you'll see that it has the Tampa Police Department evidence tag on it that identifies that specific evidence item.
Would you look through that exhibit, please, and before you tell me what's included in there, just let me know if you identify the records in that packet.
Yes. Yes, these are all items from those Celaya reports.
And would that include the physical device extraction and your review of the iCloud extraction?
It does.
Thank you. At this time, Your Honor, the state would move to admit State's Exhibit 35.
No objection.
Same objection, Your Honor.
All right, same ruling. Any other? All right, hearing no other objections, it will be admitted as States 35.
Permission to publish, Your Honor.
Granted.
You spoke very briefly just now, I'm showing you page 35, page 1, about the photo that you take. Tell me what happens once you actually receive a physical device to your unit.
So when I get the device, as you can see, this white tag, that is what is assigned to it by our evidence department. So the top number that ends in 539-1, that is the control number. So that's specific to that item in evidence. So that's what, from our unit, we focus more on that because we are getting the item from evidence and not from a person. So as it gets to us, that's the identifier that we use.
In States 35-2, do you also photograph the device itself?
We do.
I'm certain, you photograph it in the casing if there is one and without it?
We just, as we go through and take photos, we try not to manipulate the device if we don't have to, so we take photos all the way down. So what it looks like when we first get it, all the way down to if we have to remove SIM cards or SIM trays.
For our purposes, do you utilize that number you just told us about to confirm that the extraction reports are what you were looking at?
Yes.
Now I'm going to show you what's been marked page 3 of that same exhibit. Do you recognize this page here?
Yes.
Can you please explain to the jury what we're looking at?
This is essentially what you could refer to as like a face sheet or device details for the extraction. So this would be everything you would see on the phone or about the phone, like serial numbers, potentially phone numbers, or device info like identifiers.
Does the extraction report or this face sheet include the phone number associated with the device that the extraction comes from?
Yes.
And where is that located, or where can we find that?
It's actually, where it says MSISDN, I don't recall exactly what that acronym stands for at this second. So lower, yeah, right, down, 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 right there. MSISDN. And then to the right, you'll see there's the 813-953-6476.
And are you able to also see user account names associated with the device, or account names that were recovered from the device when you pull this face sheet?
Yes, you can see that Celebrite has identified 18 account names.
Now, is this account users that are on any of your extractions, even in general, does the information that's included there, is it limited only to, a legal government name, or what information is able to be put in there?
Whatever user account that was entered by a user.
Okay, so whoever has the device, you mean, or has access to this device?
Correct. It would be any identifier, email, nickname, anything that they wanted to use for, could be social media or actually the device itself.
Okay, so if Mr. Terry has John Terry 1 at Yahoo for his email on his cell phone, I hope that's not the true email address, is that what would be reflected in username in the column here?
Correct. The Celebrite goes through and pulls out usernames and then puts it in this way for us to view it. So Celebrite has identified it as a username and then just puts it here for us to see.
Is it essentially the program categorizing each of these different areas from the device?
Yes, I don't choose the term user accounts. That's what Celebrite uses and then puts these identified user account names into this category.
Is there additional information that you are able to also obtain from the username category that's provided by Celebrite? Meaning, does it include all of the usernames which would have been registered as, quote, a username when it pulls it?
Yes, all the ones that it can identify.
Now, if we're looking there at page number 4, when you pull at least the original extraction, are you also able to narrow down the categories by which you hope to search?
Yes.
In your review of the content from the physical device from Mr. Hammond, can you please describe for me whether you were able to access web searches?
I was.
Or web history, and can you tell the jury what that is?
Yes, it's what, again, Celebrite takes the extraction and then parses out databases that it identifies as being searches that were done from the device.
In looking at page number 5 of this Celebrite packet from the Hammond device, were there searches related to, or were there Google searches provided?
Yes.
How is it that you know what the Google searches were or what the content was from that?
Celebrite, again, has pulled this information out of the device, and you can see that Celebrite on the far second from left column, as you can see here in the bottom, there's the number 4, just meaning that that's the 4th row, but the search is on the second column, says 4-year-old shot in Tampa video footage, and then Google search. You can see the application that they were using on the far right, where it says yes, but next to it is Safari. So he's using, or someone was using the Safari internet application or browser to do a Google search, and then that was the search, the 4-year-old shot in Tampa video that was conducted.
Now, if I can please go with you in just chronological order here, if I may. Why is it that in looking at number 1, for example, in the column, the title is empty?
I don't have an answer for that, other than Celebrite is pulling this information out, so it might be kind of like an Excel spreadsheet or a table. Maybe that portion of that table just no longer had information in there, but it still had the URL in that table. It either was deleted and hasn't been written over yet, or maybe part of Safari was starting to clean itself up in the background, but some of the information is still available, so it's still going to provide it to you, but the information that wasn't available, excuse me, just leaves it empty because there is no information to provide.
In line number 2, if we start there, was there some information regarding the date and time of the access to this search?
Yes.
And where is that located?
It's in the, what would be the 4th column, and we see it's August 24th of 2021 at 8:02:44 p.m. UTC -4, which I believe is Eastern Standard Time, because I don't think that daylight savings times had occurred yet.
And so this would be accurate as to time in reference to the search?
Correct, as far as being in Eastern Standard Time where we are.
And then we've already gone through row number 4. Was there a subsequent search on August 24th at 8:07 p.m.?
Yes.
And has that reflected in the records as 4-year-old shot in Tampa video footage?
Yes.
Subsequent to that, were there additional searches on this device which which returned at least results depicted here. In row 5,
Yes.
did that occur at a different or separate date and time?
It shows 8/24/21 at 8:33 PM.
And now, these numbers themselves are what's been produced by the device or the program itself. Are you able to edit or modify or change that in any way?
No, these are just being all pulled from a table. So as you see, it says last visited. So it's saying that that was the last time that that Google search was visited.
And then ultimately, can you tell us the difference between those Google searches and what we're seeing in row number 8 as it relates to the content? Was this also a Google search?
Yes, it looks like yes, it was a Google search, but I'm not sure I understand the question completely.
I apologize. Are you able to determine whether there's a Google search where the ending of the search is auto-populated versus whether you've entered every single key from the information that you have here?
No, I'm not able to tell right now whether these are auto-populated or not, meaning that when you type something in Google, it then tries to suggest the rest of the search that you may be doing. And ultimately, the search is done, but I'm not sure how many of the words were actually typed out versus suggested.
And this search, it appears from the records, occurs on a separate date of August 25th at 10:19 p.m. Is that correct?
Yes, that's what Celebrate has identified.
Did you also have an opportunity to review the files for photographs?
Yes.
And were you able to ascertain whether a photograph was on this device from August 21st of 2021 at 11:17 a.m.?
Yes.
What is it that we are viewing here titled Extraction Report?
This is a photo that was identified from being on the device. And then you can see, more interesting, I guess you could say, is where the metadata is. So metadata is data specifically about the photo itself, where the created modified access at the top might be more specific to when that file was on the device. When the file made it onto the hard drive or the chip on the device, that's what those dates and times would be more specific to. But the metadata is information specific about the photo itself. So in this, we can see that this photo or device is reporting that this photo was taken with an Apple iPhone SE second generation, and then the capture time being 8/21 of 2021.
And referring you back to page 3, your extraction face sheet, can you please provide to the jury what this device from Quandarious Hammond was by model?
Yes, you can see on the left-hand column closer to the bottom where it says detected phone model, it says it's an iPhone SE second generation.
So when you're looking at states 35-8, page 8, are you able to also see on this the camera model from the device that took this?
Yes,
And what was that?
it's the same model phone that took the photo.
And on this device this photo is represented?
Yes,
Are you able to further access this photo so that it is depicted in a larger capacity?
yes,
Was page 10 of the same exhibit the photograph that you were able to extract from the device from that report we just saw?
yes,
And this was the image depicted from August 21st of 2021, is that correct?
yes,
Now, I asked you before briefly about whether you had an opportunity to review the Apple iCloud extraction for this same phone number or linked to that same phone number, is that correct?
phone number or Apple Cloud account, yes,
And you indicated you did.
yes.
Do you, in receiving those extractions, still have an opportunity to have a separate and distinct extraction report face sheet or cover page?
Yes,
Does that contain the same information that you've already described for us?
yes,
So about the device itself, it gives user accounts columns, same thing.
yes.
But where does the information on an iCloud dump come from?
It comes directly from Apple themselves, and in this case, you can see that the source where the name is actually a zip file.
Is actually a zip file?
Yeah, so Apple provides us the iCloud return, and that's what that is at the top, where it says name, and it's a bunch of numbers .zip. So that's how they provided the return to us for the cloud account.
So you would have had a file folder on a computer to open to access instead of a physical cell phone?
Correct. We don't open it, we just have the software process the entire zip file as we get it.
And in reviewing the contents of that device, were you able to note any particular, or extract any particular images from that device?
Yes.
And can you tell us from this report what this is? Is this an extraction of the image?
It's not necessarily an extraction, it's just, we get the zip file, and then we just parse the zip file. So we're not extracting anything, but we're parsing what Apple gave to us, and then on that zip file that we got from Apple, it had this photo on it.
And again, were you able to zoom on that photo and showing page 12 to view a larger depiction of that image?
Yes.
And again, no ability for you at least to document or annotate anything without there being a record of that from any of the cell phone extractions?
Correct.
Can I ask you please about whether you received a device related to defendant Jaylin Bedward in this case? I may have to give you the number.
Yes.
A little bit easier this way. Were you able to pull extractions, or were there extractions for all the devices except for one?
Yes.
And what was the difference with the one extraction for which there was an inability to get data?
I'm not sure the answer to that one.
Did
You're
you
saying-
receive a device that would not produce an extraction? Oh, thank you so much. I have a phone number, if that, would that help you to locate the device that I'm referencing?
It's the control number that would help me.
From the device itself?
No, if you're asking the extraction, like the white ticket number, I know that I have an extraction for a James Denson. But-
Yes. All devices should have an extraction. Was there a device for which, when you attempted to make an extraction upon turning it on, there was no data on the phone? Meaning it was reset?
Yes.
Okay. Are you able to tell us whether that was the only device for which, when you opened it to complete an extraction, there was essentially a reset screen?
I believe that was the only device.
What does the reset screen look like when you attempt to access it?
It usually says hello, or it'll say it in a bunch of different languages.
So like when I take a new iPhone out of the box?
Yes.
What causes the phone to give you that if it has been a phone that's used previously?
It either a factory reset that someone has done with the physical device, or I believe you can also do it by sending a reset signal to the device.
But in any event, you did not recover any information from that device?
You cannot know.
What steps are taken by either yourself or law enforcement to essentially prevent that factory reset from occurring if you impound a phone?
It's complicated because it's getting harder and harder to do that. So if you want the long answer, I can give you the long answer. But essentially, if a device has the ability to have cellular signal, it can be wiped if somebody can send the message. New iPhones that have recently come out has made it a little bit more difficult because now iPhones don't have a SIM card. The newer ones don't, so now we can't just remove the SIM card to remove it from getting signal. So now we have to put it in what's called a Faraday bag, which isolates it from Bluetooth and cellular signal. But when you do that and you can't put it in airplane mode, because now some phones require you to put a passcode in, to put it in airplane mode, as soon as you put it in one of these Faraday bags, it immediately starts looking for a signal, which causes it to drain the battery. If you drain the battery and it kills the phone, it puts it into this BFU mode, which then encrypts all of the user data. So now you need a Faraday box or a Faraday room, and it gets expensive and a lot more complicated.
No Faraday room at the Tampa Police Department?
There is not.
So when you see that the device, when you turn it on to hopefully have an extraction completed from it, gives you that factory reset screen, are you able then to obtain any content or device information?
You can get the IMEI, which is essentially the serial number or an identifier for the physical device, which you then be able to go back to Apple and try to get some information if it's there.
Can you retrieve photographs, pictures, calls from the software you have when you're trying the extraction?
From the physical device, not that I'm aware of.
It would have to be some other type of extraction or potentially something that could be recovered.
Correct. You might be able to get what I referred to as Apple images, like the images of emojis and all the flags and everything that you see on like your keyboard, but you're not going to get user or created data.
So you would see files with like the smiley face emoji and the things that come on our keypad when we're trying to text.
Correct. Things that are there by Apple at the core level of the software.
Any specific information as to the history of the device or the content from the history of the device?
No, not typically.
I'll pass the witness, Your Honor.
Yes. No question.
No question.
Nothing else to Mr. Denson?
No questions, Your Honor.
Just want to ask your clarification about one thing. You said when you did the extraction of the phone, it contains some metadata on it that gives you information as to when that picture may have been taken.
I know we talked about several phones. Are you referring to a specific phone?
The
or is
ones
that a
of the
general
pic-
question?
The ones where the pictures were introduced in this case, and Mr. Hammond.
So yes, there was metadata for the photo that was presented as an exhibit, I think is your question?
Yes.
Yes.
Oh, here we go. And then you said for the second, this is page 13, or this is the information related to the iCloud, right?
Yes, ma'am.
That you reviewed, that you said gets sent to you in a zip and then you all parse it out.
Yes.
Okay. And the photograph that the state introduced, it also has some information that's with it that we see on page 14.
Yes.
And so that information is contained in this area where it's additional file info.
Yes.
And what does that tell us?
That is dates and times that Apple has provided to us. So it's showing the created, modified, accessed, and I can't say this to be 100% for sure, but often the modified time is a good indication of when that photo was last, or when it was created.
Okay.
It's not always the case, but it's usually the first date. So sometimes it gets confusing when you look at how could something be modified, in this case, 3 months before it was created. Well, again, it goes back to, it's not really specific about the photo, it's about the file itself. So they're saying that the photo might have been taken on July 9th, but that record of that file going onto the cloud account didn't happen until October 5th. So that file being put on the iCloud was created on 10/5/21, but it might have been taken on 7/9. That's why the modified time would be 3 months before it was created.
Well, does that tell us that we don't know for sure when that picture was taken?
It's not so much about the photo, because that would be more in the EXIF information. It's about the file. So if this was a Word document, all I can tell you is what Apple's reporting is when that file itself was created and modified.
And what does it mean for it to be created in this information?
Apple is telling us that this file was put onto the iCloud server. That record of that file going on their server was created on October 5th.
Okay, and that's the same as the date and time for access under that additional file information.
Yes.
And then the modified date that we have is 7/9/2021, but you're not able to say for sure that that's when that photograph was taken.
Correct. I'm telling you, that's the last time that Apple's reporting to us that it was modified.
Okay, so unlike the other information for the actual extraction, this iCloud information that you get doesn't tell you for sure when the photo was taken.
This specific photo does not have EXIF data, which I think answers your question.
Okay, from the records that we have that are entered into evidence, does any of it indicate to us when the photo was taken?
This specific photo, no, but I just wanted to make sure that you asked if Apple has any record of photos. So to this photo, no, there's no EXIF data.
Okay.
I'm not sure if any other photos did.
All right. Nothing further.
No redirect, Your Honor.
May this witness be released?
Yes, Your Honor, from the state.
Defense?
Yes, Your Honor.
Yes.
All right, you're free to go.
Thanks, sir.
Thank you. All right, ladies and gentlemen, it's almost noon. It's a good time to take a break for lunch. So we'll ask that you come back at 1:15.
All rise for the jury.
Jury's left, y'all may be seated. So you have, state has one witness left? All right. Court being recessed to 1:15.
Court stands in recess to 1:15. Please exit.
everybody. That's 47A through E. I was asked to put them each individually. I'm not certain why, but anyhow, that's what was the request. So these are them, and I would ask prior to Dr. Webb testifying that those be read to the jury.
And they're each one separately?
Well, Judge, they asked that they each be given their own separate one, so it's basically the same thing, it's just.
All right, I'll just tell them I have,
each one.
each of the defendants is stipulated to the victim's identity. I have one copy for each, but I will read one if they are all the same.
That's fine.
Everybody
They're all
okay with that?
identical, they just each one is signed on
Okay.
paper.
I'm
All
okay
right.
with that, Judge. And then also real quick before the jury enters, I know the state will be resting soon, but as to Mr. Denson, I'll just renew all our previous motions, including the motion to adopt Mr. Gonzalez's motion to dismiss based on destruction of evidence, and assume that the court will be relying on the prior rulings made by this court or any other.
Okay. All right, thank you. Anything else?
Did you want to try and introduce the stuff? We just want to introduce, Judge, make sure we've got everything introduced, so that way, once we're done with Dr. Webb, we can go ahead and announce that we rest. So we're just trying to make sure, there's a couple of exhibits, I think, that we played, but did not introduce because we didn't have the disc yet, so I think we're trying to figure that out.
To save time, I believe all the defense parties are fine, but Ms. Bonte's headed over with it. But to save time, if we may, for the record, introduce those items, we will bring them back in because we have a number of items that still need to be corrected on the exhibit sheet. But we will introduce them and then walk them up when Dr. Webb's testimony is finished.
Okay.
Okay, Judge, 30, composite 30 is the slowed down version. That was what was played for Detective Celaya when he was there for each of the individuals. So it's a composite of each of the 5 individuals with a slowed down version from the East Tampa Pond that shows each of their actions during that day.
Any objection?
No objection.
You said that's as 30, Mr. Terry?
That's 30, composite 30.
That
correct?
is 30, A through E.
Composite 30, A through E.
No.
All right, that'll be admitted.
And then
56. Also a composite, that's just stills from each of the camera angles. So Ms. Bonte's on her way over, I'll have to confirm the exact image number, but A1 through G2 is what we have thus far. I have to look at her notes to see.
Any objections?
I'm sorry, I didn't hear what it was.
The still images from the video surveillance.
What number?
56, a composite.
Interior.
No, from all video surveillance footage, these stills that were played throughout the videos.
Was all the
There's a-
stills from the individual videos, is that what you're?
Yes.
correct. From videos that have already been introduced into evidence, we had paused at certain points and we made stills of those parts where we paused. That's what we're putting in. And we can judge after we rest.
Again,
what-
review,
We
yes.
can review them again with defense if they want to look through them and see if there's any they have any particular objection to. We can address it then. But at this time, just so that there's not a pause where we have to send the jury out, so that for us to do this, I thought we could do it now, and then we could rest when the jury's here, and that way. But it's up to the court.
I do want the opportunity, Judge, to look at the stills before I.
They want to look at them. We can't admit them.
Okay.
Do we look at them?
They're all from this video, so have already been introduced, but I understand, Judge, so we won't be able to rest right after Dr. Webb, unless we can introduce him.
Judge, procedurally, what is the plan if that's their last witness? Are we excusing the jury to then come back Monday, or what are we doing after paying that?
I would think we would excuse them till Monday. And we would, first of all, let's just start at the beginning of this cluster. So you have evidence that are just still shots of videos that are already in evidence.
Correct, Judge.
What objection could be made to a still shot off of a video?
I don't know, unless they say that they don't believe it's from a video, or they're not.
Yeah, we just haven't seen them.
I don't know I don't know, because the videos have already been introduced in evidence. These are still shots that we took in order to kind of, like, places where I paused the video,
Yeah.
those are still shots that we
And when
have.
will you have those still shots available?
I believe Ms. Bonte's working on bringing them right now.
I know, but what does that mean?
She's walking over here with them.
All right, so we'll do that when we get here.
Okay.
The next thing is, so the state's gonna call the ME, they're going to rest. Take the jury out, you can make any appropriate motions, you can do our arguments for judgment of acquittal, and then bring the jury back in, dismiss them till Monday. Then I would hope that we could go to accomplish two things. One, you'll have an opportunity to speak with your clients about whether or not they intend to testify or whether or not you plead on any case, so we can plan our next week, and maybe we can go over the jury instructions at that time.
Any reason to keep the jury here for JOA argument?
Till after them?
No, that's what, so after they rest,
We can release the jury.
we can release the jury till Monday, and then we can make our arguments at our leisure. Yes.
I know the state has emailed the proposed jury instructions. I'd like to get a hard copy. It's kind of difficult to work from the electronic copies. We can get those done.
I will see what I can do. We sent them a while ago. I have a printed copy that I printed out myself, but I can see if I can get some printed.
Okay. I mean, if it was in my court, I would just print them, but I don't have a printer here.
We sent them, I think.
I have.
Yeah, last week. so
I
just-
printed them and brought them over. All right, so, anything else?
I think that's it. As soon as Ms. Bonte gets here, we'll,
As soon as she gets here, I'll let you all look at those, we'll take care of that. Then we'll bring the jury in, I'll read these stipulations, and then you may call the doctor.
thank you, Judge. Yes, that's perfect.
All right.
Mr. Terry, can I bother you in the meantime? Sure. I just have a couple that were entered that I physically gotten in this. The last one.
Okay,
Should I just got the barcode that they're showing on the screen, so. Although would have gone with the same one. Okay, thank you so much. So that B is the second. And then 44. I think that's all. Yes, sir. I just need to get right down. Yes. So I'm just gonna mark it. I'll give it right back.
She says she's also missing.
Yes, because Ms. Bradley, the clerk is asking for 35. Can you please review the? I would offer to show the screenshots of like, I think it might be done here. Fine. Yes, do you want to? I didn't print it, I copied it, but yes, from the printer. Okay. Okay, that's fine.
Okay, no, yeah, you can.
We're ready for you to have it, we just wanted to.
Oh, okay. Like, I know you guys are still using stuff sometimes, so I don't wanna teach you.
Sure.
Judge, on States 35, that was the item that I had objected to, the stills from the phone. There was a picture of Mr. Hammond in the clothing.
Right.
We put the block on it. when Ms. Ismer put that up to the jury, you could tell a little bit more the discoloration. She kept it further out, zoomed out. So we agreed during the break to just make that block more consistent in color.
Okay.
So we did edit that, and that is the one that is going to be part of the exhibit.
That's fine.
The
Good.
image is still the same, it's just darker, essentially in the
Thanks for working that out.
waistband
Right.
area.
I still maintain my objection to that.
Absolutely. No, you've waived it once you agree.
Thank you.
45 is done? Yes.
That's, right.
Put the
Is
other,
it on just the exclusions on exhibit
yes.
one?
Did she bring those over yet?
She's on her way.
Okay,
Actually,
the
she's
reason I
actually
asked
sending
is
some.
because I just wasn't paying attention, I didn't know.
I can show them on my computer, but then I don't think.
That's okay.
Some are broken. Is this is correctly from yesterday what we worked on? Because this one was already labeled 2. Do you know any idea what's yesterday? Which ones are we excluding?
So it's up to you, because it's not right there, because it is in there as two.
Okay.
I mean,
Why don't we do this once we're done, because I would like for whoever actually jogs over here to let us get started as soon as humanly possible.
Okay, the whole pack.
All right, Judge, I believe they've had a chance to look at them. So you're moving to have States Exhibit 56A1 through G2 admitted into evidence.
Any objections?
No objection.
No, Your Honor.
No, Your Honor.
All right, they'll be admitted.
Judge, the only one I'm not sure if we admitted was 48, which is the half speed of the composite video. Is there any, we don't have that yet? Okay, well, we'll move at this time, 48, which is the composite video that was played with Detective Nightlinger only at a half speed, a slower speed.
Any objection?
No objection.
No, Your Honor.
Dan?
All right, that'll be admitted. All right, so we'll bring the jury in, I'll read the steps, and you call the witness.
Yes.
That's right here. It's coming in. So. There we go. I'm sorry? And for the record, 47A through E are being admitted, and I'll be publishing to the jury, correct? No objections to the stipulations, I take it?
No, Your Honor.
All right, they'll be admitted as 47A through E.
All rise for the jurors.
Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. Were you able to follow the court's instructions? No issues, I assume? All right, very good. All right, so ladies and gentlemen, the state and the defense have entered into stipulations. Each of the 5 defendants and their attorneys in the state have agreed to stipulate to the identity of the victim in this case. I have 5 signed stipulations that have been admitted into evidence, and I'm going to read you one of the stipulations, and they will apply to all 5 people. There are 5 separate ones. They're identical, so rather than read 5 over and over again, I'm going to read one, and they apply to each of the 5 defendants in this case. And I'm going to remind you, ladies and gentlemen, that a stipulation, I'm going to read this to you as well, the stipulations are an agreement between the parties that these facts are true. And it is, you must accept that these stipulated facts are true and have been proven. However, the significance with these is with any other piece of evidence, you may apply your own significance to the facts, of course. And in this case, the stipulated facts must be accepted as true, and they are as follows. The state of Florida and the defendant, all 5 defendants, stipulate to the following. The person who died in the shooting on the 22nd day of August, 2021, has been identified as Suni Bell, the individual named in counts 1, 4, and 5 of the indictment in this case. All right, thank you. State your name, I call your next witness.
Still call Dr. Milad Webb.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? Thank you, sir.
Counselor, whenever you're ready.
Thank you, Your Honor. Good afternoon, Dr. Webb. If you could please tell the jury your name and spell your name for the court reporter.
Good afternoon. My name is Milad Webb. First name is M-I-L-A-D, last name W-E-B-B.
And Doctor, how are you currently employed?
I am Associate Medical Examiner at Hillsborough County Medical Examiner's Office.
And how long have you been working as an associate medical examiner?
I have been in Hillsborough County since May of 2020, and then prior to that, I worked in Wayne County and City of Detroit.
All right. Explain to the jury what associate medical examiner does, what your job is.
I am responsible for determining the cause and manner of death by examining the decedent and doing an autopsy examination of that decedent to look at their tissues and look for signs of disease or injury.
All right, so, and you said you work for the Hillsborough County, so you handle deaths that occur within Hillsborough County?
Correct.
All right. Please describe for the jury what sort of educational background you've had in order to become an associate medical examiner.
I have a bachelor's degree from the University of Nevada in biochemistry. I went to medical school at the University of Nevada School of Medicine, where aside from my medical degree, I also received a PhD in biomedical engineering. I went on to the University of Michigan to study pathology as my specialty of choice. I am board certified in anatomic pathology, and then I am subspecialty trained in forensic pathology, also at the University of Michigan. The site of training for that was Wayne County Medical Examiner's Office, and I am board certified as a forensic pathologist.
All right. And do you continue to take educational courses and stuff as you continue on as a medical examiner?
I do. So to maintain my Florida license to practice medicine, as well as maintain my board certifications in anatomic and forensic pathology, I am required to do continuing medical education to keep those up to date.
And you indicated part of your duties are you conduct autopsies, is that correct?
That's right.
And approximately how many autopsies would you say you've done in the course of your career?
I have, in total, I would say I've done maybe 3,000 postmortem examinations and probably 2,000 autopsies.
And have you ever testified as an expert in forensic pathology in the courts of Hillsborough?
I have.
Approximately how many times?
I have given testimony under oath approximately 85 times.
All right. Judge, at this time, I would pass the witness if anyone has any questions.
Any questions for the doctor?
No questions. No question. No question.
All right, you may continue.
Now, back in August of 2021, were you involved in with the autopsy of Suni Bell?
Yes.
What was your role in that autopsy?
I was an attending medical examiner during the case, and I had a fellow that was training to become a forensic pathologist at the facility at the time who was performing the autopsy.
And who was that person?
Sandra Siller, Dr. Sandra Siller.
And explain, if you could, real quick to the jury what a fellow and an attending, how that works.
Correct. So the Hillsborough County Medical Examiner's Office also functions as a teaching facility. So we take residents who are training to become forensic pathologists, and they work with us for a year to develop the skills necessary to take their board examinations. So a part of our job is also to train the next generation of forensic pathologists. And that day, Dr. Siller was assigned the case of this little girl who passed away, and I was her mentor, essentially, guiding her through the examination.
Okay. And were you present during the entire autopsy?
I was.
And did you confer with her over how it was being done and her findings, and your findings, basically?
Yes.
Okay. And did you have to approve of her findings as well? Like, I don't know, who wrote the report in this particular?
She wrote the report, and then I approved the report. Essentially, we make sure that the report is appropriate and concise and professional.
Okay. All right, so you're able to testify as to everything that was done in this particular case and as to the findings?
Yes.
All right. If you can, to explain, to kind of give the jury a little background, how is an autopsy performed? What are your normal duties, how you normally go through it? Not necessarily in this particular case, but just in general, how it works.
So in general, the decedent sometimes is at the scene of where it occurred, the event occurred. Sometimes the decedent is at the hospital. In this case, the little girl was transported to the hospital. And then the medical examiner's office has to take jurisdiction of that case. So then the body becomes transported to the medical examiner's office, We receive the body and start doing a proper in-processing of the body, documenting the identification, documenting clothing, and getting them processed in order to do further exams. The examination itself starts with looking at the external surfaces of the body and noting anything that's abnormal, anything from, moles or injuries or medical devices, and then imaging of the body from head to toe, taking x-ray images, followed by internal examination of the body. So that's classically probably what you know of as an autopsy, where a Y incision is made in the decedent's body, and then we are able to look at the internal organs and evaluate the injuries or disease. During that process, we collect blood, we can collect various tissues that we can send for testing in case of like drug overdoses or poisonings, or if we need to check somebody's blood levels of certain compounds, we can do all of that.
All right, and is that how this autopsy was done with Suni Bell? In a similar
Yes, in general.
procedure? All right. Doctor, when you first observed Suni Bell, what were your initial observations regarding any potential injuries, obviously prior to going into a more detailed analysis?
There were two obvious defects on the little girl's body, on her chest, and then there was one that was apparent on her back. This was known to be these are gunshot wounds, as we had received, the basic circumstances of how she had ended up at the hospital. So we proceeded essentially as a gunshot wound case.
Okay. Do you take the height and weight of the individual?
We do.
And what was the height and weight of Suni Bell?
She was 3 feet 4 inches and 47 pounds on that day.
All right. Now, are photographs taken when you are conducting these autopsies to document what you're doing and what you're seeing?
Yes, they are.
And will they assist you and aid you in describing to the jury the injuries that you observed in this particular case and what caused them in the cause and manner of death?
Yes.
Judge, may I approach the witness?
Yes, sir.
All right, I'm going to show you what have been marked as State's Exhibit 42A through G. And I'll ask you to take a quick look at those and see if you recognize them.
Yes.
And what are they?
These are images that were taken on the day that the examination was performed for Suni Bell.
And do these pictures fairly and not accurately depict what they show in the course of you conducting your autopsy on that day?
They are accurate.
Judge, may I, at this time, the state would introduce State's Exhibit 42A through G into evidence.
Any objection to that exhibit?
No objection.
All right, 42A will be admitted, hearing no objections.
All right, I'm going to start with 42G in this particular case. I know I'm going a little bit backwards, but if you can, please, describe, does this picture, first of all, show the injuries that Suni Bell sustained, at least to the front of her body?
Yes.
And can you, there's, I think, a little stick pointer in front of you. If you could show to the jury the two defects or injuries that you observed when you came into the medical examiner's office.
Yes. You can very clearly see here on the chest, there is a defect here, and there's a defect here. These were the two gunshot wounds that were identified on the decedent's body.
Okay. Now, when these wounds, after observing them in this manner, do you label these wounds in order to help you explain them and do a report?
Yes, that's correct.
All right. I'm showing you now what's been marked as State's Exhibit 42A. Now, is this, in fact, those same two wounds that you discussed, but now here they're marked as A and B?
That's correct.
Okay. Now, doctor, there are some obvious tubes that are coming out of her body on either side of her. Did you put those tubes in, or what are those? How are those tubes there?
Those are called chest tubes. It is an emergency medical procedure. When you have trauma to your chest, there can be a significant amount of blood that fills up in your chest cavity that can restrict your lungs from working properly. These chest tubes are placed in the emergency department to drain that accumulating blood from your chest. So I did not perform that procedure. That was done at the hospital.
Okay. So when they don't take those out before they bring them to you?
Once the decedent is pronounced dead, the standard practice is to essentially not touch the decedent again. So once they say the time of death, they leave the decedent as is, especially in cases where there is the possibility of a suspicious death, for the medical examiner to examine without any further disruption.
Okay. And that way, for instance, in this particular case, had they removed the tubes and brought it to you, you would have noticed 2 more defects and had to determine whether or not they were caused by a gunshot or potentially medical intervention.
That's correct.
Okay. So when she's brought to you and you label these, how are they, you've labeled them, it looks like here, A and B, is that correct?
That's correct.
And this little thing right here, is that the medical examiner's case number?
That is correct.
Okay. And again, this is all to just document for further analysis and for potentially testifying in court and so forth.
It's for organization so that in this kind of setting, I can say we are talking about A, and then we can talk about B. It is organizational that's the purpose of it.
Okay. Now, with A and B, 2 clear defects, were you able to determine, or can you determine as a medical examiner with any degree of medical certainty the order these wounds or injuries were received by Suni Bell?
No, I cannot.
Okay. So let's start with gunshot wound. I guess we'll start with what's labeled A in this particular case.
Yes.
And I'm going to go to State's Exhibit 42B, which I believe is a more close-up photo of the injury. Is that accurate?
That's correct.
All right. Describe for the jury what gunshot or what wound A is.
So, wound A is an entrance wound for a bullet. And the way we can tell that it's an entrance wound, there are some characteristic features that we look for. It is a very round defect, and around the margin of the wound, you can see there is an abrasion, that dark ring around there. That we refer to as a marginal abrasion. On the exit side, you don't typically see the marginal abrasion. The marginal abrasion is actually caused by the bullet hitting the skin. When you're on the exit side, the bullet is actually coming out and never actually contacts the skin. It's the reverse. Looking at these features, we can determine that wound A is an entrance wound, and we also look around that wound to see, can we see any soot deposition or gunpowder stippling that would indicate if a weapon was very close to the body or it may have been pressed up against the body. In this case, we do not see any of those features. So the range of fire for this entrance wound we would classify as indeterminate, meaning that it could be at a distance, or it could have been fired closer but through an intermediate object. Like, let's say, if the bullet went through a door before it hit the little girl, or it went through a window, or it went through a car. So we don't know how far that weapon was when it fired, because we don't have any features to help us.
All right. Now, when you see a wound like this, and you've now described it as an entrance wound, are you able to follow the path of travel of that wound through the body?
Yes, we can.
Okay, and did you do that in this particular case?
Yes.
And what was the path of travel of this wound?
This bullet strikes the body, as you can see, pretty much right in the middle of the chest, and it is traveling towards the right side of her body. So it goes through her fourth rib and her sternum, and it goes through her thymus gland, which rests right above her heart area. It goes through the pericardial sac, which is the sac that holds your heart, and then it hits the top right side of the heart itself. So then it goes through the heart, and then as it comes out of the heart, it hits her right lower lobe of her lung. So it strikes the vital organs that it strikes, the heart and the lung, before it exits the body on the right side.
Okay, so the direction would then be front to back, and then left to right. Would that be right?
That is correct.
And you said the lower lobe, but is it kind of slightly downward as well?
That's correct.
All right. Was this a fatal wound?
This is a fatal wound.
Okay, is it immediately fatal or quickly fatal?
Quickly fatal.
Okay. And you indicated, I think in this case, that it exits the body, is that right?
Yes,
So this would be called a through-and-through type injury?
yes,
Okay. And so no projectiles were recovered from this particular wound, would that be right?
that's correct.
Okay. Doctor, are you able to determine from this wound what type of firearm caused this wound?
No, I cannot.
So you could not say whether it was a 9mm or a rifle or what type of firearm it was?
No, there's no residual material for me to use in that analysis.
Okay. And you indicate it goes through the body and out the back. I'm going to show you what's been marked as 42C. Is that where it exits the body?
Yes,
Okay, and 42D is a little bit closer and also has the marking on it there. Actually, I have one, 42E. Some more close-up. Is this in fact the exit wound you were discussing?
yes.
Okay. And again, you indicated that this wound would have been quickly fatal. About how long could she have survived with a wound like this?
Based on my experience, I would say 2 to 3 minutes would be expected. On the shorter range, I would say maybe about a minute. On like the longer range, maybe 4 to 5 minutes.
Okay.
But I would say definitely under 5 minutes.
And if individuals were conducting CPR and attempting to save her, would that be enough to make her live longer, or was this pretty much fatal at that point? Unless she had
This was fatal. This is fatal to the point where if this had occurred in the hospital, she probably still would have died.
Okay.
This was a devastating injury.
Now I'm going to take you back, Doctor, to State's Exhibit 42B. Tell us about 42B, the injury we see right there.
So this is also an entrance wound, but you can tell that it's distinctly different from the previous one that we just spoke about. So in B here, this is actually a very shallow wound. It doesn't go very deep, and I believe that it is just a fragment of another bullet that probably broke apart as it struck the car. And as it comes through the car, a portion of it that has lost a significant amount of velocity happens to strike her in the chest. But at that point, it doesn't really have a lot of energy behind it, and it just kind of just makes a skin wound. And it doesn't actually go into her chest. So you can tell that they are, B looks shallower, less significant than A that we were just talking about.
Okay, and so this was a projectile. That B would not therefore have been a fatal wound.
No.
Okay, and so there's clearly no corresponding exit wound. Was there a projectile or fragment recovered or something recovered from B?
Yes.
And what was
a portion of a projectile, a fragmented portion of a projectile, was removed from the soft tissue, the fatty tissue right under that wound.
Okay, I'm going to show you what's marked as 42F. Is this in fact the fragment that was recovered from the wound B that on your picture, in the picture?
Yes.
Okay. Other than these two particular wounds, did you note anything else of a wound to her body when you conducted this autopsy?
There were no other significant injuries to her.
Other than these two wounds, was she a normal, healthy 4-year-old girl?
Yes.
All right. Did you make any sort of finding as to the cause of death?
The cause of death was the gunshot wound to the chest, perforating the heart and the lung.
All right. And did you make any finding as to the manner of death?
It is a homicide.
Just one moment. But I'll pass the witness at this time.
Cross-examination.
Good afternoon, Dr. Webb.
Good afternoon.
the injuries that you located on Suni Bell, it was just the 2 entrance wounds and then the 1 exit wound on the back, is that correct?
Yes,
And when we were talking about those defects, you said only one of those injuries, and I believe that would have been wound A, was the fatal injury.
that's correct.
And this was a significant injury, as you testified to, where if she would have received it and been at the hospital, there still would have been no way to have her recover.
Very likely.
Okay, and that's because it's a significant cardiac type of injury.
Right, correct.
And in this case, you said, you testified previously in deposition that this was an immediately fatal injury, is that right?
Yes,
And that coincides with the records that you would have reviewed in this case, as far as hospital
Oh,
records
yes.
or paramedic records.
that's correct.
Prior to you either conducting the autopsy or prior to authoring the autopsy report, you have access to the records of any treatment that she receives leading up to you having contact with her.
Right, before the report is published.
Correct.
Yes,
So any kind of paramedic reports at the scenes and their observations, correct?
yes,
And the observations at the hospital, as well as any medical intervention they may have done.
yes.
And in this case, there was no evidence that she had any function after they arrived on scene.
I believe you're correct.
Okay. Do you have any question about that?
No.
All right. If I could have one moment?
Yes, ma'am.
Or I'm sorry, I don't want any other questions.
Anyone else?
I have a question. Doctor, the primary reason for an autopsy in a case like this is to determine cause of death and manner of death, correct?
Correct.
And in this case, the cause of death is the gunshot wound, correct?
Yes,
And the manner of death is homicide, correct?
yes,
And homicide means that it was not a suicide or natural causes, correct?
right. You asked 2 questions. What does homicide mean? And then it's not natural or suicide. So would
Exactly.
you like me to answer
Exactly.
that question? Or would you like me to answer what a homicide is or
No,
that it's not?
basically, it means that it happened as the result of another person, correct?
That's correct.
And it certainly, cause of death and manner of death is relevant to one of the elements in a murder case, correct?
I think that's for you to decide.
That's a fair statement.
I think you in this courtroom
Um,
decides what's relevant for that.
But your
for that
testimony
proceeding.
in no way sheds light on who may be responsible for
No,
that
that's
death,
beyond,
correct?
that's beyond my investigation.
Thank you.
Yes.
Nothing else to Mr. Denson.
No questions, Your Honor.
No question.
Redirect?
No, Your Honor.
May this witness be excused?
He may.
Thank you, Friedman. Thank you.
Thank you.
State, you may call your next witness.
Judge, at this time, the state rests.
All right, ladies and gentlemen, the state of Florida has rested its case. That leaves the attorneys and myself quite a bit of paperwork to go through before we continue. So I'm going to reset you for the day and for the weekend and ask that you come back Monday morning at 8:30. And court will be in recess until then.
All rise for the jurors.
Jury's left, y'all may be seated. All right. The state having rested their cases, I guess we'll start with Mr. Gonzalez. Any motions?
Yes, Judge. Your Honor, this may be a little bit more lengthy than the court might think, I am making a judgment of acquittal on behalf of Zvante Sampson as it relates to all of the counts he's charged with in the information: premeditated first-degree murder in count 1, attempted premeditated first-degree murder in count 2 and 3, conspiracy to commit first-degree murder in count 4, and shooting into a vehicle in count 5. In that, I believe that the state has failed to present a prima facie case as to those counts in relation to Zvante Sampson. 782.041A addresses premeditation as it relates to murder and attempted murder in the first degree. Premeditation is killing after consciously deciding to do so. That decision must be present in the mind at the time of the killing when we're talking about premeditation as it relates to first-degree murder. The law does not obviously fix that exact period of time that must pass between the formation of that intent and the killing. The period of time must be long enough to allow reflection, and it must be formed before the killing. This case is not charged as a felony murder, as the court knows, and Zvante Sampson is not alleged to have possessed or discharged a firearm. He did not actually commit a murder or an attempted murder, and therefore the only way that he can be convicted is if there is sufficient proof, and at this stage of the game, prima facie proof, that he acted as a principal. This case, I would suggest to the court, from a prima facie standpoint, rises and falls with a series of videos as it relates to sufficient prima facie finding for this case to get to a jury as to Zvante Sampson. I know that the court has not had the best benefit of the ability to see the videos that are introduced and in evidence, simply because of your trajectory, if you would. I believe that if you look at those videos individually and or collectively, it would suggest that as to Zvante Sampson, a prima facie finding has not been carried by the state. When we talk about the witnesses, Detective Celaya provides no testimony as to Zvante Sampson other than identifying him and his car, noting communications with various individuals. Some are co-defendants, some are his brother. They occur earlier in the day on the 22nd of August. They occur on 2 occasions after the murder during the same night, and certainly in the days that follow. All without any of the slightest idea what the substance of any of those conversations are. And I think that's critically important when the court decides whether or not the state has met their burden at this stage of the proceedings. He opines that he sees muzzle flashes from the vehicle, but has no evidence to provide to the jury that Zvante Sampson had one lick of knowledge as to what was going to happen. Again, Zvante Sampson doesn't discharge or possess a firearm, and therefore principles is the critical theory in this case. There is evidence that Detective Celaya provided that Zvante Sampson's phone was in the general area of the scene of the crime, but there's no speculation or nothing other than speculation as to why he was actually there at that moment in time. Willie Brown identifies no one. He does testify that Suni Bell was screaming when he got out of the car, that one vehicle had fired shots at that time prior to him running away. Mary Harrison nor Willie Brown can provide an identification of Mr. Sampson actually committing a crime. Again, I won't keep saying the word principles, but I think certainly that's the critical finding here. We know that he fired no gun. Mary Harrison testified that after the first set of shots, she started to drive, and that when they stopped, she heard Suni Bell say, "Mommy, Mommy," and at that stage of the game, it gave her the opportunity to get into the driver's seat and attempt to drive. So, what do the videos show that rises to the level of a prima facie case as it relates to Zvante Sampson? No video shows when and if Zvante Sampson sees any gun possessed by anyone.
Other than the video of them getting in the car with the guns?
Not in Vehicle 1.
Vehicle 1?
No, sir.
So the shooting that was going on in the car that he was alleged to be driving, he wouldn't have known there were guns?
No, Judge, I don't think the video nor any testimony before the court would indicate that he knew that anyone in his vehicle was carrying a gun.
There were rifle and pistol rounds all up and down Hillsborough Avenue.
Judge,
at what point doesn't he know somebody in his car is hanging out of the window shooting at someone else?
The hypothesis of innocence is certainly that when the gunshots, when the gun,
I understand the state's position.
Well, Judge, when the state can't tell us when he knows. There's no evidence before you that can tell you when he knows. When you know he knows is when it happens. That's what the evidence tells you. You can speculate when he might know, but there's no evidence to that. You can have conjecture as to when he knows, but there's no evidence to that. The only evidence there is that there is an alleged muzzle shot coming from the passenger seat of that car. And no one can speculate when he knows that there is a gun or that a gun is being fired.
He drove a car that chased down another car.
And what is the evidence that would suggest that he chased down another car?
Videotape.
That he chased.
I'm not going to argue. I'm just saying what I say. I'm not trying to debate what the facts are. I'm just stating to you what I believe the facts are. You're telling me what you believe the facts aren't or what they don't prove. I understand that argument.
No, Judge. What I'm saying is what the evidence is showing is that he drove and he caught up with another car, but it doesn't indicate, and I think it's critical to understand why. There's no evidence. No, there's nothing in evidence that would suggest
there's evidence
as to why.
There's a bullet-ridden car and a dead 4-year-old. That's evidence.
Judge, I would like to think that the fact that there's a dead 4-year-old is not what the court is contemplating when it makes this decision.
That's part of the evidence of the intent. Somebody was supposed to die that night. Probably not her, but she's the one who died. When those 2 carloads of people drove by it at 2 different times and shot it up with pistols and rifles with no regard of human life.
Judge, I don't know if the court is suggesting that that's what the state's going to be arguing to the jury.
I'm saying what I saw when I watched these videos. My vantage point was good enough to see.
Judge, what I'm trying to express to the court is that when you talk about Zvante Sampson, not
the
again.
Driver of car 1.
Driving car 1.
Okay.
A driver of car 1.
He was the driver of car 1.
What you don't see in the video is you don't see whether or not Zvante Sampson sees at the Chevron in terms of anyone else that's there. Can't see that in the video. No video shows him speaking to anyone about formulating any intent to kill anyone, to shoot anyone. That's the evidence. There's no video that shows Zvante Sampson knew what any other individual was going to do. None. 0. There's no evidence that he even knew what Quandarious Hammond was going to do when he got into the car and when he drove that car. Those are things that have to be shown in a prima facie fashion. I would also suggest that no video shows whether Zvante Sampson knew that that Quandarious Hammond had a gun.
So what your theory is, at the last second, as he's speeding down the road trying to catch the victim's car,
No, when he's already at the car.
somebody leans out of the window at the last second and starts shooting, and he never saw that coming?
Judge,
That's your theory?
it's not my theory. It's what the evidence
Well,
shows.
then that's what they'll decide also.
There's no video, Judge, that indicates whether Zvante Sampson knew there were any cars behind him. There's nothing in that video, and no car in relation to another car would indicate that he had any knowledge of that. That's what the evidence shows. No evidence will suggest the substance of any conversation, and no video tells us whether Zvante Sampson saw Willie Brown's car on Giddens. You have to rely on what's been shown and what you can see. And that, amongst many other things, you can't see based on that video, I would suggest to the court.
Okay.
Zvante Sampson's not a principal because he drove someone to somebody else's car, in this particular case, Willie Brown's car, unless there's a prima facie showing that he had knowledge. He's not a principal in this particular case because after he left the Chevron to follow Willie Brown's car, other cars followed behind him. I would also suggest, Judge, that it relates to premeditated first-degree murder and attempted premeditated first-degree murder, that you would have to find that there's been a prima facie showing that he intended the killing of Suni Bell, or he intended the attempted first-degree murder of Willie Brown and/or Mary Harrison. The state has not met his burden as to Zvante Sampson by presenting prima facie facts in those two regards. And what I'm getting to, and what I was bantering with the court about a little bit earlier, is that the law is not a question at this juncture as to who the jury believes, as you and I had a conversation about. That's not at this stage of the game what the circumstances are. It is the sufficiency of the evidence presented to send it to them to begin with. And I would suggest that there's no evidence to show that Zvante Sampson, as required by the statute and required by the instructions, intended to incite anyone or cause anyone or encourage anyone or assist or advise anyone. The only way that there's evidence to support that theory is the Chevron and the East Tampa videos. I don't believe there's anything else to support it. And individually, like I said earlier, and collectively, they don't show that. You can speculate as to what they might be saying or what they might be thinking or what someone might see about what someone else is doing. But it's nothing more than speculation. I believe that the court must find that if there's a prima facie case not supported as it relates to the premeditated, under the definition of premeditation, and the premeditation necessary for an attempted first-degree murder, that certainly that would dovetail into whether or not there's a conspiracy, whether or not there is an agreement amongst people, understanding that the law doesn't require that agreement to be something said in words. But again, the only evidence the court has to look to before a jury has an opportunity to decide this case is whether that videotape shows a conspiracy amongst individuals, Mr. Zvante Sampson, and whether it be one or any more of the individuals at that particular location at that particular time. With regard to the shooting into a vehicle, the same analysis has to take place. I won't go over it again, but at the end of the day, all that can be relied on at this juncture, the state having rested, is those videos to speculate what are in people's minds and what they might have said that we cannot hear, and what they might have seen going on in that parking lot around them that we can't just presume they did. And in my view, those are the things the court has to look at in determining whether this case gets to a jury. And as much as I anguish about this being a 4-year-old child, I certainly would take issue with the court suggesting that because it's a 4-year-old child, and because she was shot up by 2 cars, or in the court dying in the course of being shot up by 2 cars, that's part of any analysis that the court has to make.
It's not part of my analysis. I mentioned that a 4-year-old child was killed because a 4-year-old child was killed.
There's no question about it,
If
Judge.
a 22-year-old black male by the name of Brown, I would have mentioned him. But no, it was the young child that was killed, so she's part of this entire process.
Understood, Your Honor, understood. So for those reasons, and because what I believe that 30 seconds of video tells us, with no admissions, with no witness, and with, as it relates to Mr. Sampson, not possessing or discharging a firearm, I believe there's insufficient evidence to send this case to the jury as to all of the counts that he is charged with in the indictment. Thank you.
State?
Yes, Your Honor. So, Your Honor,
We're going to take each one at a time.
with regards to Zvante Sampson, it almost feels like Mr. Gonzalez was watching different videos than I was watching, because when you watch that video from that East Tampa Pond as well as the Chevron station, it is extremely clear, extremely obvious that all of these individuals were communicating with each other, they were talking to each other. The minute Willie Brown's car goes by, you see 3 of them, including Mr. Denson, all get up, they start pointing to that vehicle, they start walking out into that field, following where that vehicle goes until it parks. Then they all come running back. They each start grabbing guns. Zvante Sampson was present for all of that. They start masking themselves. Andrew Thompson puts a shirt around his face, masking himself. They're all communicating, they're all pointing, they're all getting in cars. Clearly, there was an agreement amongst them all to target that vehicle. Not only do we know that from just their actions at that store, that car then leaves, led by Zvante Sampson, I might add, gets out, pulls out, chases down, and we see, based on a series of video, Zvante Sampson's car going at a very high rate of speed to catch up with Willie Brown, who's just traveling, minding his own business, heading down Hillsborough, before he pulls up, and Judge, clearly, right as he's pulling up alongside it, we see the brake lights come on from that car. He's clearly slowing down to match the speed so the man sitting next to him holding a gun can pull that gun out, and shoot up that car to kill whoever's inside there, whether it be Suni Bell,
Was it
Willie
Thompson?
Brown.
Thompson.
I'm
tied
sorry,
the shirt
Quandarious
around-
Hammond pulled that gun out.
But Thompson tied the shirt around his head?
Yes, Your Honor. Andrew Thompson, you'll see him
He
on
took
that.
off
vi-
his shirt and
took-
tied it
Takes off his
around his
shirt,
head,
ties it
clearly
around
on
his
the
head as a
video.
mask. Yes, Your Honor.
And Mr. Sampson was standing there at that
Correct.
time.
He was right there while they were all walking
At the same time
around.
as the others were getting their guns and going towards the car.
Correct. Jaylin Bedward walks
Car
right
number
by
one
him
had
with
not
a,
left.
Jaylin Bedward walks right by him with a rifle,
That's what
Judge.
my notes are.
And then they follow him, and he applies the brakes right as they pull up alongside the victim's vehicle, while Quandarious Hammond is shooting that gun out at that vehicle. And then he turns and drives Quandarious Hammond back, drops him off so that Quandarious Hammond can go behind that dumpster and grab whatever I guess is back there, and then meets up with him afterwards. Not in this situation of a person who didn't know what was happening, didn't realize someone was shooting out of his car, and like, what are you doing? He clearly intended it, planned it, along with all the other people who were involved and the other 2 vehicles that were involved in this case. Judge, I think the state has gone well beyond a prima facie case in this case against Zvante Sampson.
I agree with the state. The state has met its burden for the prima facie case. So I'll deny the motion for judgment of acquittal as to Mr. Sampson's on counts 1, 2, 3, 4, and 5, in which he was charged. Yes, sir.
Your Honor, if I may, Daniel Hernandez on behalf of Jaylin Bedward. My client's in a similar situation, so I'd first adopt all the arguments that were just made by Mr. Gonzalez, and I'll try not to be repetitive. Mr. Bedward is in the same situation as Mr. Sampson, is that he was not charged with discharging a firearm. He is the driver of what's been referred to as vehicle number 3. I would submit that the court should grant the motion for judgment of acquittal on behalf of Mr. Bedward, because looking at the evidence in the light most favorable to the state has not presented a prima facie case as to all counts regarding Mr. Bedward. I would submit that there has been no direct evidence that the defendant was a principal or co-conspirator. There's no communications, there's no statements, nothing that would support the fact that my client was a principal or a co-conspirator. The state is relying on circumstantial evidence, and I would submit that the state's evidence does not eliminate all reasonable explanations of innocence, so therefore the matter should not go before the jury. I would submit that no evidence has been presented, certainly not enough for a prima facie case, that Mr. Bedward had knowledge of a crime that was about to occur. There's no evidence that regarding any criminal intent by Mr. Bedward, nor any evidence that Mr. Bedward willingly and knowingly agreed to enter a criminal conspiracy. The state is simply relying on inferences based on the defendant being merely present with his co-defendants when a fatal shooting took place. So I would, on behalf of Mr. Bedward, ask the court to grant my motion for judgment of acquittal.
And he was charged in counts 1, 2, 4, and 5, correct?
Sir?
1, 2, 4, and 5 were the counts that your client was charged in, not count 3 and 6, correct?
Correct.
Right.
Yeah, I'd have to double check, but yes, I believe
Right.
that's correct.
I will deny your motion for judgment of acquittal. I find that the state proved the prima facie case. This is to Mr. Bedward on counts 1, 2, 4, and 5. Mr. Fischetti.
Good afternoon, Your Honor. Thank you. Daniel Fischetti on behalf of James Denson. I would make a motion for judgment of acquittal as to counts 1, 2, 4, 5, and 6, working backwards to number 6, shooting from the vehicle. There's no evidence before the court that Mr. Denson knowingly and willfully discharged his firearm, even though the evidence is that he had shell casings associated with items 43 or markers 43 and 44, which was to the west of the final resting spot, the point of reference laid out in the state summary. As to counts 1, 2, 4, and 5, as the court recalls from the evidence, at the time that Willie Brown is an occupant of the vehicle at 45th Street, he exits, goes down there. Vehicle 3, which the state has alleged that Mr. Denson was a part of, was not on scene at that point in time. And given all of the arguments that have been made, I understand that the court is familiar with it and has made its notes, but there's no evidence of any muzzle flashes coming from a 9mm, any type of masking, any type of arming. As the court knows, he did have a concealed weapons permit. He did lawfully purchase that firearm that he later pawned approximately 30 days after the incident happened, after this was a case that received massive media coverage in the Tampa area. And I would say that it's a reasonable hypothesis of innocence for him to be acting in that manner. So I would ask the court to grant Mr. Denson's motion.
Based on the state's previous argument and my rulings, I'll find that Mr. Denison, I'll deny the judgment of acquittal as to counts 1, 2, 4, 5, and 6.
Thank you, Your Honor.
Mr. Sonardi?
Thank you. Good afternoon, Your Honor. On behalf of Andrew Thompson, we'd obviously renew all previous motion, including motion for severance that was previously filed, the court has previously denied, and also the motion in limine that, in reference to the narrations by Detective Celaya and Detective Iverson, and at this juncture would adopt all of the arguments previously brought forth by co-defendant counsel. The evidence in this case, taken in the light most favorable to the state against Andrew Thompson, is basically the videos. That's all there is. There's no other evidence. No one identifies Mr. Andrew Thompson as the shooter. He is simply identified at the gas station as allegedly being present at the gas station and entering the vehicle. He's not alleged to have possessed any guns. He's not shown to have had any guns. None of the evidence puts a gun in Mr. Andrew Thompson's hands. I submit, I again adopt the argument by Mr. Gonzalez concerning the subject of premeditation. We submit that there is an element of whether or not there was an element of premeditation in the first-degree murder allegations. Secondly, as to the conspiracy, the only evidence brought forth by the state is the speculation and conjecture of the activity of the individuals at the gas station. There is no evidence of an agreement. The only evidence of a conspiracy is the state's interpretation of the actions, the movements of the individuals. That's it. There's nothing else.
The tying of his shirt around his face to hide his face?
I don't know how that's a part of it, of an agreement, Your Honor. It has to be an agreement. That's not part of an agreement. That may be alleged the independent act of Mr. Thompson, but it's not.
I understand your point.
It's not a part. It's not an agreement to commit any crime. Again, there's no admissions by Mr. Thompson or anyone else in that matter that incriminates them. Everything that is concerning the conspiracy is total speculation and conjecture. There are no phone records that connect Mr. Thompson to the scene. Mr. Thompson's phone is identified quite a distance away from the area where the shooting occurred. Actually, it appears to be the center of that appears to be on I-4, which is away from the scene. I submit, and also there is a contradiction, if you will, in the state's charging documents, in that in count 1, alleging the murder of Suni Bell, that 3 individuals possessed a firearm, and that alleges Mr. Hammond, Mr. Thompson, and Mr. Denson. But in count 5 of the indictment, the state alleges that 5 people shot at the vehicle, including 2 additional ones that aren't charged in count 1. So there's a discrepancy in the state's own allegations. I submit to you, based on the lack of evidence, conflict in the evidence, that the court grant a motion for judgment of acquittal as to counts 1, 2, 4, and 5, and 6 as to Mr. Andrew Thompson. Thank you.
Based on the state's argument and my recollection of the evidence, I'll deny your motion for judgment of acquittal as to counts 1, 2, 4, 5, and 6, finding that the state has presented a prima facie case.
Thank you.
Ms. Bradley.
Your Honor, I'd renew all previous motions and objections and obviously move for judgment of acquittal as to all counts related to Mr. Hammond. I'll adopt the arguments of all of the co-defendant attorneys, and I'd also just like to point out to the court, I know you made a mention of individuals hanging out of vehicles. There's been absolutely zero testimony by any of the witnesses, including the detectives that watched these videos repeatedly, of anyone being able to be identified out of the windows, that there was any evidence of guns out of the windows. They couldn't even tell from the video footage whether windows were up or down at the time. There's been
Are you
also,
suggesting that all of those shell casings were filed from inside a car with the windows up?
I'm suggesting that there is evidence that's been presented, and none of that evidence has discussed at all any individuals hanging out of the vehicle, any windows being open. That's what the testimony's been.
Logic dictates that if you're going to fire a weapon inside of a car with the windows closed, that the shell casings from these semi-automatic weapons, as the expert described, would have been ejected and remained in the vehicle. The only way those shells could have been lined up for almost 1,000 feet down Hillsborough Avenue is if the guns were shot from an open window. So I believe that was a prima facie evidence there.
I understand that that is circumstantial evidence related to it, but I'm talking about the video that has been observed repeatedly and testified to
With the muzzle
repeatedly.
flashes to show windows were open?
But when we questioned them,
Question who?
the
Right.
detectives, several times, none of them were able to say that any windows were open when we asked, could you make determinations about the windows? There has not been any testimony from those
I
detectives
understand that. but
that
it's the-
reviewed
The
it.
trier fact on the prima facie part of this, that's, I believe that the state has met its burden in that regard.
I understand. I want to make the record clear as to what the actual evidence has been, though. There's been no
Well, the final
eyewitnesses.
determination of that will be on the jury's decision. I understand.
Correct.
You may perfect your record.
There's been no eyewitnesses, there were no independent eyewitnesses. The only individuals to be able to testify about what happened on that day were Mary Harrison and Willie Brown, and neither one of them, aside from saying there was a black vehicle similar to an Infiniti, were able to identify whether windows were up or down or who were the potential shooters in the case. There's also been no evidence that the state has presented that there's been any animosity between any of these individuals. In fact, the testimony that the state put on is that
Wouldn't
there
that go to
is no
motive?
relationship. Excuse me?
Wouldn't animosity go to motive?
Correct.
And
And would,
motive's not a fact that they need to prove.
but intent to kill is something that they have
Intent to kill, yes, but you don't have to have a motive to intend to kill somebody.
I agree. However, prior relationship between the parties is a proper consideration into whether someone intended to kill or not.
It can
And in
be.
this case, we have a situation where the parties do not know each other based on the state's own testimony. There's been no statements at all from anyone as to the motive or reason for the shooting, because there can be a shooting without an intent to kill. That can be separate. So what I'm asking the court to consider are what the facts are in the testimony in this case. And so there has not been any testimony related to any kind of animosity other than
So you're
just,
asking me to consider that there was a shooting without an intent to kill?
I'm asking you to consider that there's no relationship between the parties, no prior animosity, when considering the mindset and the intent to kill.
Maybe a case of mistaken identity. I don't think they intended to kill the 4-year-old girl.
You're free to make whatever determinations you want, but I do believe the facts in the testimony related to a lack of a relationship and animosity and no motive or intent in that sense, because the intent has to be inferred by actions.
Well, I inferred it from watching their excited actions when this car drove by, that they went and chased down.
And
And
you're
it seemed to me that they thought they knew who was driving that car.
And you're free to make whatever determination you want, but I do believe that you should also consider the fact that there has been nothing presented related to any kind of relationship or animosity between the parties.
I
The
understand
only
that.
thing that has been testified to is just a noticing of this vehicle and then obviously actions afterwards. So based on all of that and the prior arguments, I would move for a judgment of acquittal for Mr. Hammond.
All right, regarding Mr. Hammond, I'll deny the request for judgment of acquittal on counts 1, 2, 3, 4, and 5, and 6, based on the state's presentation and my recollection of the evidence, that they have met their burden of proving a prima facie case. All right. Next. Have you all had an opportunity to speak with your clients and about testifying or not testifying? And are there any witnesses you plan on calling or recall, or calling from the state's list as well? I know Mr. Gonzalez had mentioned the possibility of calling the witness back to the stand.
Judge, I don't know if any other defendants can go through a colloquy. I'd like them in.
Oh, yeah, we can take all the time you need. So you want to take a 15-minute recess?
Thank you.
All right, Mr. Dennison, raise your right hand. You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. You heard what I said to the other two, your co-defendants in this case, that you have the right to testify and not to testify.
Yes, sir.
And that's ultimately your decision. If you choose not to testify, which it appears that might be the direction you're going, I'll instruct the jury that they're not to consider that and any form of guilt or have any problems with that. You understand that?
Yes, sir.
And after speaking to your attorney, you have decided to not testify, that's true?
Yes, sir.
Nobody's forced you or threatened you to make that decision?
No, sir.
All right, thank you, sir, very much. Mr. Sonardi?
Your Honor, perhaps Mr. Thompson, our conversations indicate that he does not want to testify.
All right, Mr. Thompson, could you raise your right hand? You swear affirm any testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you understand you have that right, you can put your hand down. You have the right to testify or not testify. As I said to the other folks, that if you decide not to testify, that I will instruct the jury that you're exercising your right to remain silent. They should not have any concerns or use that as any evidence of anything. You understand that? And you also have the right to testify if you wanted to on your own defense. You'd be cross-examined by the state attorneys and things like that. And after speaking to your lawyers, you've decided not to testify? Has anybody forced you or threatened you to make that decision? All right, thank you very much. And Ms. Bradley, regarding your client.
Judge, in light of Mr. Sampson saying that he is going to testify, I just would say that at this juncture, I don't believe Mr. Hammond is going to testify, but it may change based on anything that Mr. Sampson says.
I understand that, so let me colloquy him. Sir, could you raise your right hand? You swear or affirm any testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, sir, you understand that you too also have the right to testify on your own behalf. You also have a right not to testify, and I will instruct the jury that by not testifying, they are not to consider that as any evidence of guilt or be concerned about that at all. Do you understand that? Yes, sir. And if you do testify, you'd be the subject of cross-examination and possibly rebuttal witnesses and things along that line. Yes, and you've had an opportunity to speak with your attorney about both of those options? Yes, sir. And you've decided at this point, you can always change your mind, but at this point, you've decided not to testify. Not testify, sir. Right, not testify. And has anybody forced you or threatened you to make that decision? No, sir. All right, thank you very much. All right. So having said that, are there any other witnesses that you all plan on calling? Just some good thinking of the timing and scheduling.
Judge, I have indicated to the state that and she is on notice and she's under subpoena by the state, crime scene tech Boyd, Bailey Boyd.
Okay.
But the testimony would be extremely short.
All right, and if you could just let the state know what day you may need her on, Monday, I
Judge,
suggest.
it's Monday or never.
Okay, all right. All right, anything else?
Judge, can we deal with the jury instructions?
Yeah, that would be the next thing. I just want to make sure we got everything else done before we move on to that.
Before we're done for the day as well, we just have a couple of issues that we need to address on record with the exhibit numbers and things like that, but that is absolutely procedural.
You want to do the instructions now?
What I was asking is, unless anybody has a major objection, can we do those Monday?
Why would we waste time Monday when we have another 2.5 hours now? No, they're not going to change, right? And it doesn't mean we can't readdress any issues that come up, but 90% of these are standard. So I prefer to work while we have some time. So let me get to where we would jump in. So basically, how do you want to do it as far as resting and then having Mr. Gonzalez call his witness? Have him call his witness first and then let him rest?
I'm sorry, Judge, were you talking?
Well, we're talking about the logistics of resting, not resting, calling your next witness, that type of thing, on the defense's case in chief. So Monday morning, I'll say, Mr. Gonzalez, you may call your first witness, and then you can call your witness. And if you're done, you rest.
Or we could rest.
Or you could rest. You could change your mind and rest Monday morning, not testify. Whatever. But then we'll just go down the line, and everybody else will make their decision. Once,
Right, for the jury.
right, and then once you rest in front of the jury, I'll ask the jury to step out, and then we can renew all of your motions, and then brush up again on the jury instructions if there are any last-minute things, and then just go into closing arguments, if time permits.
Does anybody, if we're going to address jury instructions this afternoon, hey guys, if we're going to address jury instructions this afternoon, does it make any sense for us to sit with each other first and discuss them, or are we ready to just discuss with the board?
I think we can go ahead and start. I mean, like, again, as the judge said, most of these are standard. I just took them straight from the book and just put in the name. So, I mean, if there's any issues, I can address them and change them this weekend. That way, Monday, we're all set.
Forgetting 10 copies.
I have emailed you know what, I don't know that I emailed you, Danny, because I don't think I had your email, so, but yeah, I will get card copies for you.
So I guess the first pertinent instruction would be statement of the case, which follows the instruction of the
Hold on, Judge,
Closing
I don't
arguments.
think Mr. Hernandez has a copy. Give him mine. Judge, can we do the exhibits real quick, that Ms. Customer needs to take care of, and I will, in the meantime, see about getting Mr. Hernandez a copy. I know the rest of them, I sent a copy, but I don't believe at the time I sent it.
Maybe in Judge Sabella's office can do that. In Judge Sabella's office, maybe can do that.
I told Christina she's done.
I can print, I can't copy.
You can print a copy, correct?
I can send you a copy. Right.
Yeah. Okay, so while they're doing that, maybe Ms. Ismer can go through put on the record the issues with some of the evidence that was put in, because we had to remove some of them because there were objections and that sort of thing, so you want to take care of that one?
Sure. Any that you don't have here with you. Yep, here, 30, yep.
Just 30 and 48.
Okay, 30 and 48. Good. And then I just sent you an email with what we have as well, just maybe that is helpful with your notes. Shoot, it takes a second to email from me.
Can they, Brian, do you have?
All right, do you want to
email?
Can you
start
email
with
your
what you
copy
had
to her?
Or you can email it to me and I
Highlighted,
can.
your little bit that you had highlighted of what the problems were? Was it just one? He sent me a list. Did you find it?
Yeah, Danny, can you forward it to me and I'll forward it to you?
She said 27. You have 27A through 27Q.
Because I wasn't on the original.
You weren't on the
So
original.
it was just missed, like we can
I just realized it was all.
update the exhibit list and correct that.
How was it?
Yeah.
Oh, yes, because we had to remove some. Okay, gotcha. That is 27. But that is not a change to anything that's in evidence, so I don't need to alert any, okay.
It was addressed.
Okay. Oh, it's already been changed on our hard one, okay. 35 through 38. Are all, B. That's correct. Oh, that's correct. C. So we have 35 composite. A and B, right?
Did he email it to you?
Oh, okay.
Yeah, it's just, I'm sure it's just taking a
Then
while to
tell
come
me
in.
which one you don't have.
Okay.
That is correct. What, it's just crossed out here. What do you want me, do we need to do anything? Do we need to put anything? Okay, let me just annotate that so that we can announce what we don't have as actual exhibit numbers.
Do I need to help you, or you guys?
No, I'm actually gonna work from the email, actually. Thank you. Yes. How about 39?
No, that's what we don't have.
Oh, okay.
38B to 40,
Correct.
41 and 41B.
So don't put A.
Because it was just
Oh,
admitted
yes, it was admitted
as.
as. Okay. So it's 41 and 41B.
Correct.
Got it?
42A through G.
Oh,
Never mind, I got it.
42A through G instead of F. Okay? Let me make sure I've done this other thing correctly. Nope, I'm gonna make them here because you are not permitted to make, like, update the numbers if we move. Okay, so, yeah, I'll just resend this to you. No, I was just having to compare the two, but I have notes from Katie about whatever you told me yesterday.
I emailed you whenever you get a chance. I can bring you my stuff if you look at the one I've been using.
I'm gonna use the notes we had from yesterday, and I'm just gonna run down the list to make sure we're right. So 41, 41,
This isn't what I sent you, is it?
No, I had this from, I just had this lying around in
I
my
looked at
office
it, I
somewhere.
went, oh my God, did I
No.
send him an old, like,
No, this is, I was lying in my office, I grabbed it so I'd remember Independent Act. There's a couple things that we're gonna end up talking about, I'll tell you now, is that, first of all, I believe that the order of the defendants in the instructions should be the order of the defendants in the indictment. So I'm gonna ask you to, you know, to state the names of the defendant.
53, A through D? Correct. Yep.
Might have been the easiest thing to think about doing.
Yeah.
But I want to make sure that it goes in the order of the indictment. I think that it should mirror the indictment. That's what's already done. Yeah. It's all right, you're going to have to redo them anyway. I mean, you can tell somebody already to just start flipping them all.
Yep, okay. Okay.
The other thing we're going to ask for, Donnie, is, you know, we think that each
You have those, right?
substantive
I did not see those already.
offense
There's some, they might be here. They're up here somewhere.
Okay.
I just saw.
But they're in.
Yes.
Okay.
And then that's all I have.
And then you have documented defense exhibit.
Yeah, I have defense.
Okay.
substantive offense should have an instruction for each defendant.
Okay, so the rest of it is okay then. Let me resend this just
I know,
to
I
make
get
sure
it.
they have our, I guess.
you'll be reading instructions all day long.
But, you know, here again, you know, when they get through the entire cases, that's a big issue, you know, five people's names, you know, you're
Excluded on 1R, which
in my mind, you're predisposed to simply think, okay,
I mean, you make your
So
argument.
1DD, 1EE, and 1
She would laugh so hard. She would look at you like,
are all excluded from exhibit 1. Okay.
me too. You know, I mean, he's certainly gonna
Was that
have
the only
to shit
exclusions?
on Quandarious Hammond.
But it is A through L in the land report.
Plus, she's probably gonna get up there and fucking.
I'm updating this and I'll send it to you.
All right. So the first one, 3-2, statement of the charge.
Judge, I plan to address it how you asked, so I'm going to cut each one in count 1, in count 2, and count 3, and include the names of the individuals charged for that.
I think it just makes it clear for the jury.
And I'm going to do, and Mr. Gonzalez as requested, and I'm going to do it throughout. It's going to take me a while, but I'll do it this weekend, but to have the names listed in the order, I guess they are for the indictment, which is Hammond first and Sampson. So I'll get the order changed.
Okay.
I'm not sure why I did it in this particular order. It might have been just how I had them in my head, but I will switch it around and change it to the correct order as they are listed in the indictment.
All right.
So
Then the next 3 instructions, 3.3D.
I can't hear you, Judge.
Oh, yeah. Sorry, I got to turn this on. So the next section, so the possession of a firearm and discharge causing death. And so we have one which refers to Mr. Hammond, Mr. Thompson, Mr. Denison. And then the other one refers to Mr. Hammond, Mr. Thompson, Mr. Denison, again, an attempted. The first, of course, was the actual, then the attempted, and then the third one would be Mr. Hammond committed attempted first-degree premeditated murder of Willie Brown. The definition of firearm is given in each of those. Anybody object to those 3 the way they are?
In the 3.3D.
Yes.
When it comes to, maybe I have an old one, but when it comes to Mary Harrison and Willie Brown, it shouldn't say the cause of death. I don't have the new one.
Right, so on the ones where there was no death caused, should it say causing death? I don't think so.
I'm sorry, I was trying to figure out which one you're talking about.
Like 3.3D, possession of a firearm and discharge causing death. And in the Mary Harrison, and then the next one being Willie Brown, there was no death. It was attempted first-degree murder.
Causing death.
In the title.
The top.
Oh, the title, I'm sorry, yes, Judge, it should say maybe death, okay. What should it say? 3.3, possession of firearm and discharge causing death. Okay, so I'll take out the causing death for the 2 attempted ones.
Okay.
I also think they should say or and not and.
As far as the two victims?
Wait,
You see where she's at? Or?
and instead of or?
It should say or instead of and for the defendants.
Hammond, Thompson, and should be or Denson.
Well, or should it be and or, because or makes it seem like they have to make a choice between them.
They do. They have to make an individual choice with each of these defendants about whether they possess and discharge the firearm.
So I will say and or. I'm not going to just say or, because that makes it sound like they can only choose one. So I will do and or, so that means they can choose 1, 2, or all 3.
That makes sense.
Your Honor, from my perspective, and not trying to be difficult, but anytime you have a conjunction, when you're listing defendants together, whether it's or, I think it can create confusion where someone could be charged or convicted for the act of another as opposed to their individual actions. Even though there is a principal instruction, even though the jury will be instructed under 3.12C that you have multiple counts and multiple defendants, and that a separate crime is charged against each count, I do think that the use of conjunctions is error. Whether that becomes fundamental error upon conviction depends on, some of the other facts that go into it, but I'm not trying to make the court read something too lengthy to the jury, but especially since it's going back with them, I would love.
Well, if it says or, then the jury could only pick one of them, and the other 2 could be found guilty.
Well, I would love if it would say if you find that my client committed a crime and my client
three instructions.
Basically, he's asking for three of the same instructions for all three, which would total 6, 7, 8, 9. You're reading this charge 9 different times.
I'm just gonna read it once and say it applies.
Understood, Your Honor.
So that's what I mean, that's why I put in the and/or, so that it applies to all.
So, we're gonna try to pare it down.
So, do we agree it's gonna be an and/or?
I'm gonna put and/or for now. If you have any research over the weekend, and come in Monday and show me something that says that's an error, I will abide by the law. I think that since principle's been the underlying theory that and/or kind of gives them the options that they need, but I can be persuaded.
So Judge, this weekend I will add and/or between each of their names.
Okay.
All of these instructions, including suppression of firearm and discharge.
In the 3.3D, when it comes to Mary Harrison at the bottom, where it says to actually possess, it should, for those two elements, it should be A and B.
Oh, yeah.
Yeah, the letters are off.
Yeah, I'll fix that.
Okay. All right. Lesser includeds. Lesser included of first-degree premeditated murder or second-degree murder or manslaughter. And the lesser included crimes of attempted first-degree premeditated murder, attempted second, and attempted manslaughter. Concur?
I would agree that the category 1 lessers would apply in this situation, that there's been no facts to support any category 2 or other lessers.
Any differing opinions? Okay. Principal instruction. This is the standard one that we seem to always give. Any objections for the record?
We're gonna move on to lesser included.
We're getting there, we're just going, they'll be in here in a minute. The lesser included are those 4. 2 for the first-degree murder and 2 for the attempted first-degree murder. I don't think they're lesser included on the other charges, right?
Sorry, where are we at, Judge?
We're just revisiting the lesser included.
Yeah, those are the category 1 lesser included for these
Right.
charges.
So now we're on the principal instruction.
And I'm going to take out that attempted homicide cases.
Do the italics part, yeah.
The italics part, yeah, I'll take that out, and I'm gonna do an and/or between Willie Brown and Mary Harrison, so it's clear that it could be either and/or.
Okay. 3-7, plead not guilty, reasonable doubt, burden of proof.
I did not put in any sort of affirmative defense, because at this point there has not been any, so I'd let that paragraph in case something develops or there is going to be some sort of affirmative defense, but otherwise I'll remove that paragraph.
So, yeah. Well, you're going to leave the part that says the defendant is not required to present evidence to prove anything, correct?
Yeah.
Yeah, all right. Everything else standard? Any disagreements?
Judge, just for the principal instruction, can we, like at the end of when it says, like, attempted first-degree premeditated murder, can we, like, put in parentheses for these, like, count whatever it is that it's applying to?
I'm sorry, I don't understand what she's saying.
Like where it says for first-degree premeditated murder, and just put maybe like count 1, and attempted first-degree premeditated murder, count, 2 and 3, just so like they're given some guidance as to what counts we're referring to.
So she's asking to insert the numbers of the counts in which you're saying that the principal theory applies, which would be counts 1, count 2, count 3.
It would just be as to the counts of those charges.
Count 4.
I don't know that it's necessary to include the counts that they are, because it's the same thing. Attempted first-degree premeditated murder is the same in both counts, whether it's counts 2
Yeah,
or
but
3 or...
is there a principal theory on count 6?
There is actually, yes.
Okay.
We need to add that.
So it would apply on all counts. Anybody disagree?
Okay, I will add that count.
Okay. Everything good on 3-7?
Again, I will leave it as the defendant's not required to present evidence or prove anything, except if in the course of Monday, from the defense develops, I will put that in.
Judge, that's what I was waiting before. We jump on to 3-7. On behalf of Andrew Thompson, we are going to request an independent act instruction under 3.6L, it looks like. Independent act. As
Regarding which count?
the counts that he's charged in, which I believe are 1, 2, 4, 5, and 6. And then 1, 2, 3.
What evidence is there to support that instruction?
Yeah, that's what I don't understand. So,
Well, the only evidence is that Mr. Thompson allegedly got in a vehicle that shots came from. So easily could have been any one of the two other occupants of the vehicle that shot.
right.
And he was
that's
just
why-
merely present.
That's why they're saying it's the principal theory. They're all in it together. That's the state's theory.
Correct. Our theory is it's the independent act of co-defendants, specifically Mr. Bedford and Mr. Jensen, who were alleged to be in the same vehicle. There's no evidence showing that, the only evidence connecting Mr. Thompson to any of this is his alleged placement in the vehicle. That's it.
Well, he was tying he's the guy that tied the shirt around his head to mask his face.
Well,
And got into a car with a bunch of people getting in there with guns.
there could be other explanations for that, Judge, that I don't intend to get into here, but there are other explanations for that.
Well, I'll be waiting to hear those, but I don't see any evidence that would require that instruction at this time. No one else, does anybody just want that for your client as well?
Reserve, Judge, on a potential request I may have.
Okay.
Yes, Your Honor, I'd be asking for that as well.
Judge, I think in order to get that, there would have to be some evidence of that. Now, I
Yeah,
understand with
what
Mr.
evidence
with
other
Mr.
than-
With Mr. Gonzalez, if his client takes a stand, maybe there'll be some evidence developed that would allow that instruction. So I will make or have the instruction ready, but I don't, at this point in time, Judge, the state will be objecting to that instruction because there's no evidence presented that there was any sort of an independent act.
At this point, I don't see any. Now, that might all change with defendants, if any defendants want to testify, and it becomes every man for himself at that point.
Even just the evidence of the casings themselves and the grouping and the fact that the vehicle that Mr. Hammond is alleged to have been in turns before additional shots are fired, that is all, can all be part of an independent act.
I disagree. If you can bring me case law that says otherwise. It's all right. Anything else on that? So we'll bring up both because we don't know which way it's going to go. 3-9, weighing the evidence. 1, 2, 3, 4, and 5.
I don't think we need 6, 7, 9.
6, no, I agree. 7, no. 9, well, 9 we don't know yet. I
Yeah,
mean,
that's correct, Judge, that's, yeah, 9 is up in the air.
So 8 for sure, and 9 is questionable, depending on,
So I'll create 2 of these 3.9,
Okay.
one with 9 in and one with 9 out.
all right? Expert witnesses, accomplices, and informants.
I don't think that's necessary.
That doesn't apply. Then the give, if defendant testify, we'll wait and see. If that case, if that line comes in, we'll get rid of the italics. If it doesn't come in, we strike the whole thing, of course. And then 3-9A, defendant not testifying again. That will probably be, I'll probably be reading them both. And that will be applying to different people in different circumstances. So I'll have to read it, one defendant, when whoever decides to testify, I'll use their name, like, Mr. Jones, for an example, decided to testify on his behalf, to testify He's become a witness in this case, you apply the same rules to his testimony as you apply to the others. And then defendants so-and-so, so-and-so, and so-and-so, for example, regarding them, the Constitution requires the state to prove the case, blah, 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 and the defendant exercised a fundamental right, blah, blah, blah. Any objections to doing it that way? Letting the jury know that these guys didn't and these did, or if that's the case. So we'll be flexible in that regard. Defendant's statements, there were defendant's statements definitely made out of court, so we'll read that instruction unless there's any.
That what?
What? 39B, defendant's statements.
Who are we referring to?
Right, can we refer specifically to who it is instead of just saying defendant?
Because there are no statements other than it was present, applies to Mr. Andrew Thompson.
Well, right, some people did and some people didn't.
Well, Mr. Thompson admitted, they all did. Every defendant made a statement.
They made a statement.
Because even Andrew Thompson admitted that it was him that was in that video that was shown to him when Detective Celaya came to see him. So I can put statements claimed to have been made by the defendants, and just make it plural, if that makes it.
So they all made something.
I introduced a statement from each and every defendant in this case. So
All right.
I think it would apply to all of them.
So make it plural.
I'll make it plural.
310, the seven rules of deliberation. Those are standard. Any objections? No. Deciding a verdict, just,
That's standard.
yep, cautionary. The verdict form is blank. I don't have a verdict form.
I sent it in a separate email, I believe.
Well-
Or it was also attached to the jury.
When did you send that?
I sent it to you as well, I believe. I know I sent it to the defendant's attorneys.
To me? When?
The verdict form?
Yes.
Yeah.
Correct, I
I
have it.
believe I sent it to your honor as well.
I know, I'm just asking when you sent it.
Oh, around the same time I sent the jury instructions.
Because I never got an email.
Same day, within.
Yes, September 8th. I believe I sent it to everybody at that time.
I don't have it.
Does you like me to forward you that email with the verdict form in it? Is that helpful, or do you want to?
Just, if you could, I don't know. If you send it to me, just forward it to me. I'll bring it up on the big computer.
Otherwise, Judge, the 3.12 instruction is, I will, since there is one verdict form, the only thing I'm going to change in there is just to make it so it's a verdict form, not forms.
Judge, are you the trial division?
Just send it to robin.fuson
Got it.
and then blah, blah, blah. Yeah, nothing of the other emails go to me.
The business nurse sent it to you.
Oh, wait a minute. This was out of order, I do have it. I had one that said verdict form with nothing, and then I guess what you included got printed and given to me later after the fact. And I just got your email, so thank you. I'm well prepared now, I think. So, before we do the verdict form, you want to go over the charges?
Sure.
'Cause I had these out of order.
We can work from the
All right, so, introduction to homicide. And I'm going to read these, of course, after the statement of the charges. So 7-1, everybody take a look at that one.
So 7.1 is okay?
Hold on, let me get to there. Yeah, that's standard.
So 7.1 okay for everyone?
Yes, I think that's standard.
Any objections to 7-1? That's uncertain is approved.
Mr. Terry, do we want to change paragraph 3 and 7.1 to reflect the consensus earlier to, regarding and or not?
Okay, I will again put and or between any and all of these defendants whenever there's a charge about this.
Okay. This is now instruct you on the circumstances that must be proven before the defendants can be found guilty of first-degree murder or any lesser included. That takes us to 7.2, murder in the first degree.
Again, on paragraph 2, I will add and or between all the defendants.
That's a standard murder instruction, right?
It is.
7.4, murder
Standard.
second degree, that's standard.
And I will add again and or between all defendants.
7.7, manslaughter.
Again, standard, and I will add again and or.
6.2, attempted first degree premeditated murder.
Judge, there is a missing instruction for 6.1. I'm going to add that, just so the court's aware. I thought I put it in there. I know I asked my secretary, but I don't think I added it to this instruction that was sent to all of you, so I will make sure it gets added.
What is 6.1?
6.1 is the introduction to attempted homicide. It's basically the same thing as the introduction to homicide, but it says attempted. It's almost identical, you know.
Yeah, it just basically says what attempted first-degree premeditated murder is, and then says I'm going to explain to you what they are, and then I start reading the definitions.
Yes.
All right, so the 6.1 will be inserted, then we go to 6.2.
Yes, sir. And again, similar, I will add and or between all
Except,
defendants.
it
And I will
says in
change the
here that
order.
May Harrison is dead.
Yeah, Mr. Fischetti just pointed out to me.
Yeah.
I'll make that Mary.
Okay. So those changes will be made. And then attempted first-degree murder, again, it says Willie Brown is dead. So you change that. Other than that, standard. Attempted
sorry.
second-degree murder,
You are changing the is dead language? We were just changing Mary.
well, Willie Brown is not dead.
Correct. So on the attempted murder instructions, the standard language on attempted murder for each of that secondary category say that the state would have proved essentially that that the following occurred, or
Yeah,
would have occurred had the person died.
So it
instead of
has to say,
survived.
it has to say.
Oh, I see what you're saying. Where?
So under 6.2, attempted premeditated,
Right.
Yeah, we have to say is dead, because that's what we would have had to prove had. it
Oh,
been-
I see what you're saying.
Yeah. I know it did make a lot of sense to
Oh,
me
yeah,
too
yeah.
when I read it, but I kept going back and forth to the instruction, and that's what it says I have to do, because had the attempted
you.
killing occurred, that's what we would have had to prove.
So we're saying that the attempted first-degree premeditated murder reflects Mary Harrison and Willie Bell? Is that what we're
Willie
saying?
Brown.
I mean, Willie Brown, I'm sorry.
Yeah, it has to include the language on the bottom that they are.
So they have to prove that if they were successful, they would have been killed.
Correct.
Basically.
Correct.
All right.
It's-
And if they
Because
can't prove that what they did would have resulted in their death, they can't prove attempted first-degree murder. Right?
correct.
Correct.
Okay, it's just confusing, that's, believe
It
it.
It's
is,
a bad instruction.
it's a bad instruction, it's very confusing, but that is the standard, and so I'm going to follow it.
6-4 attempted second-degree murder. That
Again,
looks
standard.
Standard. And again, 6-4 is a repeat of that, just changes the names of the people involved.
Mr. Chair, do you want to keep the numbering on 6-4 as it relates to Willie Brown, 4, 5, and 6?
No, I don't know why that did that, so I'll fix that number to 1, 2, and 3 again.
Okay.
Oh, yeah.
All right. 6-6, attempted manslaughter by act. And then again on 6-6, the other one, 3 and 4 should be 1 and 2 again.
Yeah, I don't know why the computer did that, so I apologize.
That's all right.
And on all these, we're doing the and/or.
Correct, I will do the and/or.
Right, on all of them.
Criminal conspiracy, 5-3.
That's standard. I don't believe, Judge, in this particular instruction, I don't know that I don't believe I do the and/or between them, since it's considered a criminal conspiracy between all of them. So,
Well,
if anyone has any objection, I'm leaving that alone.
well, it can be a conspiracy besides less than all 5 of them. Could be a conspiracy between 3 or 4 of them.
I just worry that'll confuse the jury. I don't know how they can find, if it's and/or, they can't find a conspiracy between one, it would have to be at least 2.
Correct.
So if it were to include or, I believe is confusing because what.
I don't think or is appropriate.
I kind of feel like that's one that I don't see how I do an and/or on that.
I would agree.
Okay, I do too. Because you have to have more than one person for a conspiracy.
Correct, but you don't
Or
need
we
5.
couldn't- We don't have to have 5, you could have 2.
Correct.
But
So that means 3 would have been not guilty.
I'll look at it, Judge, and see if maybe I can find an instruction that says, while all are listed.
do you want them to list who they say conspired with who? Or is that even feasible?
I know, I don't think of
Judge, look, let me work on that this weekend.
I know
see
what
if
you're
can
saying.
Come up with a definition that might get everyone, let everyone, something that says that the conspiracy does not require all 5, as long as at least 2.
Whatever the statutory
Well,
language.
like I could
is, it
conspire
says
with
2
you
or
and you
more.
could conspire with her and that we would all be in a conspiracy.
Yeah, let me look at the language of conspiracy and see if there's something that will clarify
Okay.
that. So we can just kind of leave that one open, and I'll come up with some potential suggestions on Monday.
This is the standard instruction.
This is the standard instruction, but I don't know how it applies when you have 5 co-defendants where maybe one person was not in the conspiracy. I don't know.
Well, then that would be reflected on their verdict form.
I kind of agree, Judge, so that's kind
Believe
of.
it, yeah, that's the way it works. So it's and then they'll be able to decide in the verdict form if any one or more individuals did not conspire and find them not guilty of it.
That's true.
So they could find 2 conspired and the other 3 didn't, or they could find that all 5 didn't conspire, or any combination of that. All right.
Your Honor, can you defendant plural, the last sentence, it's not necessarily the defendant doing act further into
Defendants, right?
I'm sorry, where, Judge?
the last sentence.
The last sentence, that the defendants do any act in furtherance. That the defendant, instead of the defendant, should be the defendants, right?
Okay.
Okay. Shooting at or in a vehicle, 1013. Standard?
Yes, and/or.
And/or again.
I don't know how you might want to fix number 2, where it just says he. I don't know if you want to put names there also, and do an and/or. Right.
Instead of he, do you just want to cut and paste all the names of the defendants there on 2?
I can, Judge, yes.
And 10-6A, discharging a firearm from a vehicle within 1,000 feet of a person. Standard, and it lists the names of the people that they claim.
Sorry, Ed, before you move on 10.13,
Yes?
bottom paragraph as well, you can take out she.
Yeah, we just, Ms. Ismer just noticed that. We fixed it.
All right. Ten six A, standard.
It's standard, and I'll make it into it.
312, multiple accounts or informations, multiple defendants.
That's standard, Judge.
Do we need the word informations?
Sorry?
It says multiple accounts or informations, multiple defendants.
I can change informations to indictments since this is an indictment, but if there's not multiple.
Well, it's one indictment,
One indictment, yeah.
so it would just be multiple accounts, multiple defendants,
Okay.
since there's only one indictment. Okay,
Yes, Judge.
What number is that?
that's 312C.
312C, I'll change it to the title will be multiple counts and multiple defendants. That's how I'll title it. The language of the paragraph itself is standard from the jury.
Right, and it refers to the indictment instead of multiple, so we're good. 313 looks standard, I looked at this one earlier.
Judge, do you have a preference between court deputy or bailiff?
No, it doesn't matter to me. Sometimes I just call them the guys with the uniforms on.
I'll probably just make it bailiff then, since that's just one word. It's easy.
Okay. All right. And then in closing, let me remind you, that's standard. And then the verdict form, I'll be reading that before in closing. Let me get it in the right place on all of this.
Heading needs to change.
Yes, I just supposed to tell me to do that.
Change the heading, you're changing the order.
Correct.
Is because the indictment say Sampson, not Webb.
It says him.
Yes, I can just, all the only change is that this person's just look at the top of the very thing. Oh, you are.
This is the order. It's Hammond, Sampson, Bedward.
All right, so then at the end, let's see. So I read 311, then I read 313, submitting the case to the jury. And before, the verdict form.
Judge, we can go back to 3.2 for a second. At the top of that,
Which one?
3.2 statement of charge.
Okay.
I believe it should just say statement of charges, since there's multiple, and can we add after crimes of murder in the first degree premeditated, just to track what's already in the attempted murder, just put of Suni Bell?
Well, he's going to redo the whole statement of the charges thing.
You want me to add of Suni Bell?
Just because it's the same as what you have in the others, attempted murder of Mary Harris and attempted murder of Will Brown.
Well, I included their names because there's 2 attempted murders to differentiate the two, but there's only 1 murder, that's why I didn't put somebody else in. I can add that if you want, but the reason I had to add Mary Harrison and Willie Brown is because otherwise it doesn't make any sense to read attempted first-degree murder, premeditated murder twice without explaining why we read twice.
Where's the instruction that talks about the verdict form?
Which instruction, Judge?
The one that says, the verdict must be unanimous, and for your convenience, a verdict form has been provided.
You know what? Isn't it under the verdict? Isn't it in the verdict where I say?
I think we're missing that one.
It's under verdict, right?
It's under 3.12.
3.12?
I can't find 312. So I'm not saying that I don't have it, I'm just saying I can't find it.
We have it in here, Judge. It reads, "You may find the defendant guilty as charged or guilty of such lesser included crimes as evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been..."
Let me just find it. I know, when I was trying to find a verdict form, I moved the piles around, and it may have gotten moved to one of these others.
Yeah, it's 3.12, though, Judge.
Yep, there it is. But there's another one, though, somewhere. Now, this is the multiple counts or informations, right?
Correct.
But I need the one that says, the verdict must be unanimous, that is, each of you must come to the same verdict.
It's 3.12, Judge. It's the third paragraph.
I have only 3.12C. I might keep looking, I got some more to wade through here. Anyway, just make sure that that's in the packets. There's 310, 311.
It should be in there, Judge, 3.12, but I'll make sure.
See, I go from 311 to 313. And I don't see the regular 312. Just make sure that I get that one, okay? All right, so let's go over the verdict form then.
I just sent via email the reordered verdict form of the defense's request. We can go through each defendant, but they're now in order of charging, so switching Hammond and Sampson.
Okay. On the verdict form?
Yes, I just sent it via email, and I included Madam Clerk, the court is in
All
her.
right. So count one looks okay? And we have count two, which has A, B, C, and D, but they have qualifiers under for the first three, correct?
Yes, Judge.
All right. And then count one. Indictment is the Quandarious. Count one of the indictment is the Jaylin Bedward, A, B, C, D. Andrew Thompson, A, and then the qualifiers, and then the lesser included. Count two look okay, folks? Anybody see any discrepancies other than what was previously mentioned on the verdict form?
Mr. Chair, let me ask your thoughts on count two for the specific findings.
On count two?
Mr. Terry?
We're listening.
Okay. for example, under Mr. Denson says the defendant is guilty of attempted first-degree premeditated murder of Mary Harrison, and the defendant actually possessed and discharged a firearm causing death. If we're just talking about Mary Harrison, do we need to have that specific finding in there? Because I wouldn't want somebody to believe that if the death of Suni Bell was caused, that you could get that aggravator as to Mary Harrison. Does that make sense?
Yeah, that should be removed.
No, we will take those out. You're correct.
Yep, all right, that's good.
So we will remove all those that say anything that says causing death on either Mary Harrison or Will Brown.
Oh, causing death, I see what they're saying.
Having said all that, I'm sure there'll be some tweaks and twists before Monday, so we'll be ready to go back over those again at the appropriate time. I think we got most of the heavy lifting out of the way on those.
Did the court's intention to do closings Monday after?
If we get, I mean, how long do you think closings are gonna take? Most of the day, I think.
Probably half of it.
I know, so we have, so let's just say that we get through after lunch. I wouldn't want to go into closings in the afternoon and push it. So then we could tell everybody that, and then everybody's rested. It's after lunch, we've rested, we'll just send the jury home, ask them to come back Tuesday morning, and let them know that that's when closing arguments will begin. And that way, nobody's
But
pushed.
if Monday morning comes and Mr. Sampson decides he doesn't want to testify,
If by 10 o'clock in the morning, the defense is rested, then we'll go into closings. Maybe have an early lunch, and 11 o'clock lunch, and then start at 12:30, 12:15, something. We'll play that by ear, but if we're done early enough Monday, we'll go into it. But if we're finished after lunch, I would rather wait and come back Tuesday so that all parties have ample time. Because you're gonna go, then these 5 folks are gonna go, and then you're gonna go again. So that's gonna be 3 or 4 hours probably.
Have you, court decided about how much time you want to get each defendant?
Whatever y'all need. I mean, you're allowed to split whatever time he does. How long do you think your closing will be?
well, Ms. Ismer's going to do the first closing, I'm going to do the rebuttal closing, so combined together, an hour and a half total probably between the two of us.
So if you each wanted an hour and a half, I would give you that. I mean, I would give you more if you really wanted. I'm not gonna press you, but I can't see the
No.
person again. But know that you have up to an hour and a half.
That's fine, that's more than enough, I think.
Does that sound like a reasonable amount?
Yes, and Judge, if we end up doing closings Monday and closings finish up at, 4 o'clock, 5 o'clock or something like that, are you going to instruct them? Or are you gonna have them come back the following day and instruct them and let them deliberate? What's your thoughts on that?
If we're that close, 4 o'clock-ish, it would probably be better just to bring them back in the morning, read them the instructions, and send them off fresh.
Bring it
Unless
up.
somebody strongly
I don't know
disagrees.
what you're talking about, I'm not clear what you're talking about.
Judge, one other issue I want the court to be aware of prior to Monday, especially prior to closings. There's been a lot of discussion about the reasonable hypothesis of innocence as being standard. Because the state has put on both direct and circumstantial evidence, that standard does not apply. So we're going to be objecting to any sort of argument regarding the reasonable hypothesis of innocence, because that is not the standard. We have put on direct evidence in this case. We have video evidence, which is direct evidence. We have put on
Let me ask
evidence
this
of...
threshold question. Doesn't the reasonable hypothesis of innocence only apply when the only evidence is circumstantial?
That's correct.
So
Yes.
therefore, I would caution the use of that hypothesis.
That's why I wanted to
Both
make it
direct
clear,
and circumstantial are in this case.
Correct. I think there's been some confusion because I've heard people making that argument, and that argument does not apply in this case. So they cannot make that argument to a jury and say anything about reasonable hypothesis of innocence, because there has been direct evidence put on in this case, and as a result, that's not the standard anymore.
For the record, Judge, we object to the fact that the state is alleging that there is direct evidence. There is no direct evidence, it's circumstantial evidence.
Hold on 1 second.
I don't know what video evidence would be if it's not direct evidence.
But it doesn't identify anybody, just identifies
It
vehicle.
identifies him getting into the,
That's it, identifies vehicles.
Or always.
there's direct evidence.
So according to my staff attorney, who's funny in a good way, he indicated the Supreme Court did away with the reasonable hypothesis.
I think it
And
did.
put everything
but-
into the judgment of acquittal standard, so y'all could argue reasonable doubt, but not reasonable hypothesis of innocence.
That was my understanding too, but I hadn't found that law, but I did find this that says if there's any direct, they don't get that argument. So I know that for a fact, but I also, that's what my understanding was, but I couldn't find that direct case, but I do recall they got rid of that.
And Judge, I'm sorry, I didn't hear what the court
The
said.
Supreme Court did away with the reasonable hypothesis of innocence, and they left it now to that JOA standard. The defense's arguments are more in line with reasonable doubt. All right. Anything else? And I'll have that case eventually.
Oh, I thought we were going to do it.
Yes, I'm adding that.
Off the record. Can we, it's nothing to do with this case.
Can we go off the record?
Can I address the court on a different matter? You know, because I filed it a while back and I haven't, it gets bounced around. After it got set, I found out my daughter is getting married.